Yes.
Yeah, please, your lordship. My lord, one matter, criminal petition, my lord, that was came up on 14 to 2025. Criminal petition.
All mention memos.
My lord.
If it is for today only, mention, otherwise give it.
Where is the lordship? 29.
They are permitted. Whenever she'll give the dates. It can all not come on a same day. So we'll have to she'll make some adjustments, give it.
Item 43, my lord. That has received, my lord, with time, my lord. Can be after 7, my lord? 7:11.
Rahul Nath, POSCO.
That has been received, my lord. We need.
What time?
Not today, my lord.
What time?
Have to go through, my lord.
What to go through? You have the statements with you. Then the victim girl, she's around 5 years. Huh? He is a barber. Not a fit case for bail.
6 or 7, my lord.
Mr. D. Bora, learned counsel for the petitioner, prays that he be that the matter be adjourned on account of personal inconvenience. Full stop. Prayer is not objected to by Mr. K.K. Parasar, learned additional public prosecutor appearing for the state. Full stop. Registry to list this matter again on 10/11/2025.
Wait, please, your lordship. Item 50.
50. CD not come. Huh? You're on interim.
Lordship.
When will you get it, Mr. Parasar?
10th of November.
Mr. K.K. Parasar, learned counsel for the petitioner, submits that he be granted further time to produce the case diary in the matter. Also, accordingly, registry to list this matter again on 10/11/2025. Also, interim order passed earlier to continue till the next date of listing.
Lordship.
There is already a case pending. Huh?
Same is.
You're for the
Appellant.
appellant.
Petitioner.
Criminal petition, huh?
The question.
You want an adjournment?
I have not annexed charge. I have challenged charge, but I have not
How
annexed.
can on the same fact situation, there be two proceedings? Huh?
Even the Supreme Court has so many.
And if the second issue is correct, the first will not survive. I was to stay the thing. He wants an adjournment, we'll give him an adjournment. Mr. A. Khonikar, learned counsel for the petitioner, prays that he be granted further 10 days time to
Next week, but
10 days time to file an additional affidavit to bring on record the charge sheet filed in the matter against the petitioner. For sub prayer accepted, registry to list this matter again after 10 days on a date to be fixed by it. Yes. You should take your chances.
I beg to mention for item
26.
1 week. Today have some
Sorry, wait.
1 week.
Why?
My senior is
This case, the CS was filed sometime in 2024. Where were you? Call Mr. Ali. We are not adjourning. You go and appear. You have not been appearing. Summons is of April 2024. Where were you? Nothing in your petition. Call Mr. Ali. We'll see. Yes. If
Evidence against conviction. Delay, in-depth delay.
today,
Please, your lordship, I beg.
51. It's already mentioned. Huh?
50 or
50
not?
mentioned. Is it?
51.
Oh. Why? Prayer is made on behalf of Mr. P. Noy, learned counsel for the petitioners for an adjournment in the matter on the ground of personal inconvenience. Also, prayer is not objected to by Mr.
Also not received, my lord.
Mr. K.K. Parasar, learned additional public prosecutor appearing for the state submits that the case diary has also not been received. Accordingly, registry to list this matter again
11th
on
of November.
11/11/2025, on which date Mr. Parasar shall produce the case diary of the matter. Case diary of the case.
There is an interim order.
Interim order to continue till the next date of listing.
I beg to mention for
Why?
bad. Time may be given. Lord.
We'll consider the matter when it is taken up. We have noted your prayer.
Like to mention item number 35, my lord.
Hmm.
Reason for the day, my lord. My senior is not come for his health position, my lord. 35,
Supari case. Case of Supari.
my lord.
Case of Supari. Huh? Civil nature.
Yes, yes, my lord.
You missed your bus. On a prayer is made on behalf of Mr. J.I. Borvia, learned counsel for the petitioner for an adjournment in the matter on account of personal, is indisposed.
My lord. Well, my lord.
That's it. On the ground that he is indisposed. Full stop. Prayer accepted. Registry to list this matter again after viral fever. What?
Kidney
Tom?
problem, my lord. Kidney problem.
After 4 weeks on a date to be fixed by it.
Hey, please, Rashram, my lord. I beg to mention item number 46, my lord. Call for CD again.
Did he not received? 46.
I'm sorry, please.
It is that bank robbery. No. No. What is the issue here? What is the charge against you?
Anuddin, my lord.
What happened? Case diary not received.
Not received, my lord.
Mr. K.K. Parasar, learned counsel for the learned additional public prosecutor, praised that the case diary has submitted that the case diary has not been received and accordingly praised that the matter be taken up on
10th.
10/11/2025. Full stop. Prayer accepted. Registry to list this matter again on 10/11/2025, on which date the case diary shall be produced by the learned additional public prosecutor.
Yes, Lordship. I want to mention BA 2029 of 2025. I want to withdraw this petition as it is imperfect.
Monday. Yes.
Your Lordship. Was arrested on 25/9/2025. FIR is page number 10, Lordship.
Mr. Parasar,
My lord.
whether just get the instruction whether this meat that was seized was sent for forensic science lab examination or a veterinary expert opinion.
Yes.
Because he says it is buffalo meat. The allegation it is beef.
Beef.
So we will have to have if there is no FSL, that cannot be established. Your name?
Lordship, S.Y. Ahmed.
Heard Mr. S.Y. Ahmed. Also heard Mr. K.K. Parasar, learned counsel for the learned additional public prosecutor. Issue notice, call for the case diary. Registry to list this matter. Case diary along with FSL report. Registry to list this matter again on
On 3rd.
3/11/2025.
They were arrested on 25/9/2025 and they were forwarded to 2nd October 2025. After March,
Let us get this only the case if there is no FSL. It cannot be sustained against you.
Lordship.
Violation of 48, POSCO. We'll get the case diary, we'll see.
Notice has to go to the.
Notice, respond number 2.
Two.
But Mr. Z Alam, learned counsel for the petition, also heard Mr. KK Parasar, learned counsel appearing for the respondent. The present application has been instituted, praying for regular bail to the petitioner in connection with South Salmara PS case number 118/2025 under section 329 bracketed 4/64/62 BNS read with section 8 POSCO Act. Also issue notice. Mr. Parasar accepts notice on behalf of respondent number 1. Full stop. Petitioner to take steps for service of notice upon respondent number 2 by speed post steps within 2 working days from today. Full stop. Call for the case diary. Charge sheet has not been filed.
No.
Registry to full stop. Registry to list this matter again on
Or fifth floor.
6/11/2025.
My please, your lordship. Herein, your lordship, the commercial quantity, but the contraband was recovered from some other accused person. And he was arrested from his home, your lordship, after 2 days.
But she is in.
You are the main kingpin. Allegation that you are the one who is involved in the interstate trafficking. So we'll have the case diary. But Mr. A.M. Khan, learned counsel for the petitioner. Also, Mr. Barbuja, present application, Yate Paisaba, Bongaigaon GRPS case number 86/2025 under section 20 bracketed B bracketed Roman 2 small C/29 of NDPS Act. Get a notice, issue notice. Call for the case diary.
10th of November.
Registry to list this matter again on 10/9/2025. What happened to the other co-accused?
They have already apprehended here.
Apprehended behind the bus.
Should have the diary, man. We'll have the diary, man. My lord, diary is available in this court, my lord, because another co-accused case closed up on last Friday. Can it be on, my lord, 30th of this month, my lord? 30 or 31?
But heard Mr. N.J. Duttal on a counsel for the petitioner, Mr. K.K. Parasar, additional public prosecutor. Issue notice. Call for the case diary. Registry to list this matter again on 30.
30 or 31?
30.
I'm obliged.
2025 for production of the case diary. Step further.
Along with the
Scan
Scan
copy,
copy of the
first
FCF.
it is, my lord. Scan copy is equal.
What is the stage of the trial? You don't know. We can't know.
the evidence stage, my lordship.
The victim has been examined.
Spite of several
He did not turn up. Heard
after one
Mr.
PS.
P.S. Raja, learned counsel for the petitioner, also heard Mr. K.K. Parasar, learned additional public prosecutor. So, the present application has been instituted, praying for regular bail to the petitioner, who was arrested on 23/4/2025, in connection with Special P case number 31, bracketed BGN, bracket over, /2025, under section 376, bracket AB, yet sile over there, oblique 376, bracket 2, bracket small n, bracket small f of Indian Pen IPC, read with section 6 of the POSCO Act. Full stop. Issue notice. Call for the trial court records. So registry to trial court records. Also, registered to list this matter again on 6/6/11.
Alias notice issued, my lord, alias.
Notice issue. Issue notice করেছে তো? Yes, Mr. Bora.
We went to deliver our child. I've been held for.
Child marriage, POSCO, rape.
No, child marriage.
How old
also.
was he?
As per the FIR 17, page 9.
So when the offense occurred, she was 16.
Maybe lordship.
Maybe means yes. So the consent, if any, it's of no use.
They're happily married otherwise.
Married means that is no marriage in the eye of law. So the act done upon her will invite POSCO. We'll see. VP Bora, KK Parasar, issue notice, call for the charge sheet has been filed. No.
No.
Okay, call for the case diary. Registered to list this matter again on
7th.
7/11/2025 for production of the case diary.
Please.
How many witnesses are there? 10.
That's not yet, we accused 10.
No. Witnesses. Witnesses, how many?
Here. After initial rejection, my lord,
Amsu
Who-
comes in.
two witness examined.
No,
After-
five witnesses.
Altogether 5.
Ah.
After rejection, last time rejected by this honorable court, by my lord Justice Pathak.
Hmm.
In between, my lord, for last about, my lord, 5 months, only
Hmm.
2 witness examined. They have also not, my lord, implicated the petitioner, my lord.
No, they are only with regard to the age and the
This is the, my lord, POCSO case.
but the victim girl has implicated you.
Case is that whether she is minor or major. This
She is
the-
minor,
this is the
2007.
fundamental basis of.
2007.
And your lordship kindly see the certificate that was of.
That is something which the trial court will take into consideration. It's not something we will now adjudicate upon.
The age, my lord, is the trial.
11 total out of 11 so far, my lord, I am 1 year, 5 months, 7 days as on today. Only 5 examined. 6 still remain, my lord.
We'll also have to see why the delay is taking place, whether you are also contributing to that.
No, not because I am in the hell, my lord.
No,
Every,
your counsel
have never taken.
taken time.
So far, my information is. LADC is appointed. So there is no question of, my lord, adjournment.
And the rejection was sometime in 2024. Last time?
Section order here. 21/2/21, February 1.
Yes, Mr. Professor.
It will take some, but all the.
Second option is, I have also taken up the next ground, my lord, regarding notice, etc. There is no.
Now today that ground we are not going to entertain.
Basic
regarding-
thing, your lordship, my lord, this is the fundamental basis to determine the
We'll
age.
take a report from the trial court and then status report from the trial court with regard to the proceedings and then possibly we'll keep it next week.
Fine.
But Mr. A. Ayuddin, learned counsel for the petitioner, also Mr. KK Parasa, learned counsel appearing for the learned additional public prosecutor for the state. So the present application has been instituted praying for grant of regular bail to the petitioner in connection with special bracketed POSCO bracket over case number 63/2024. Under section 366 IPC read with section 4 of the POSCO Act. Issue notice also. registry to requisition the copy of the trial court records along with the status report from the trial court with regard to the stage of the trial. Full stop. Registry to list this matter again on 30/10/2025, 31/10/2025.
Time of life.
Section 4, basically.
Basically on the, my lord, age. Because the prosecution,
At this stage.
No, I only want to satisfy whether the delay is because of him, that much only.
My lord.
When were you arrested?
Lord, on 24/9/2025, my lord. But it is a matter of, my lord, dispute of civil nature between the tenant and the landlord, my lord. Now,
No, this case is not that. This case is the attack on the police by 2 persons.
allegation, my lord, and already are behind the bar for
Heard Mr. A.K. Bhuya, learned counsel for the petitioner, also heard Mr. K.K. Parasar, learned counsel appearing for the petitioner, for the additional public prosecutor appearing for the state. Arrested on?
24/9/2025.
And your brother is still on anticipatory bail, interim anticipatory bail. The present interlocutory application has been instituted by the petitioner, present application has been instituted by the petitioner praying for grant of regular bail in connection with Nilam Bazar PS case number 133/2025 registered under section 121 bracketed 1/132/296/351 bracketed 2/109/3 bracketed 5 of the BNS 2023. The petitioner herein was arrested in connection with the said case on 24/9/2025 and the petitioner is presently in judicial custody. Also, this court has perused the materials brought on record. From the FIR, it is revealed that the petitioner herein along with his brother had behaved in an aggressive and hostile manner with the police party who had gone to their house, and the police were obstructed by the petitioner and his brother from performing their lawful duties. The FIR also discloses that the petitioner herein had assaulted one SI, Jontu Sharma, and even tried to kill him. Also, it is seen that the present petitioner is behind the bars from 24/9/2025. Also, the lapse of time occasioning in the matter since the institution of the registration of the FIR involved would lead to a presumption that the investigation in the matter has reached at an advanced stage. Also, accordingly, considering the length of detention undergone by the petitioner herein, as well as the time elapsing from the date, as well as the nature of the offense involved and the time elapsing from the date of registration of the FIR, this court is of the considered view that further custodial detention of the petitioner herein would not be called for. So, accordingly, the petitioner herein is directed to be released on regular bail on furnishing a bail bond of rupees 30,000 bracket 30,000 with surety of like amount to the satisfaction of the investigating authority, subject to the following conditions. Also, the petitioner herein shall appear before the investigating officer as and when.
Already.
Hear my thing. Don't jump your gun, Mr. Bhuya. I may not be having a very big knowledge about criminal law.
My intention.
Shall appear before the investigating officer. Charge sheet has not been filed. Investigating officer as and when called for in connection with the investigation of the case. Also, the petitioner shall not temper hetu ase paragraph to lagai diba. Also, the petitioner shall not leave the jurisdiction of the, which is the court?
Lord, Honorable Chief Judicial Magistrate Sri Bhumi.
Chief Judicial Magistrate C. Bhumi without prior permission. Also, next, any violation of the conditions of regular bail as set out herein above in this order would automatically lead to the vacation of the liberty granted to the petitioner herein by this court. Also, with the above observation and direction, the present bail petition stands disposed of.
Bhuya, my lord.
Oh, A.R. Bhuyan.
My lord, I am
After-
sorry for the interruption in the duration. Oblige, my
That was already 2 minutes back. I have forgotten.
lord. Oblige, my lord.
May I please your lordship?
Huh? Hey. Maybe. Mr. We are fixing this matter on Wednesday. Let him complete his instructions. We'll take it up. Yes. He's just been arrested. We will not pass a final order today.
Oh, your lordship, just see,
That is what I want to have the.
lordship may inquire from him,
That is what we'll direct him to take all complete instructions, come back.
He appeared before the Chief Magistrate. Just let him come, so that if he can say that he had notice has been issued.
How can he have, whether he has that notice today that this matter is taking
He appeared and he has noticed, we have some copies on him.
timing?
If he says, the notice has been issued,
Fine.
it please your lordship. The regular bail application, my lord. The FIR is at page number 13, the type copy, my lord. And the contents of the FIR as reflected in the 79 is at page number 16, my lord.
From where did you get this FSL report?
My lord, by applying the certified copy in the office of the office in Majuli, my lord. That is,
This report has come to the office. From there you have taken a
yes, my
certificate.
lord. And it's at page number 29. And signature and the report at page 34, my lord. It states that the sample confirms the prescribed standards as laid down in regulation 2.3.1 of food safety and standards, containment, toxins and residues regulation with respect to the tests carried out. So this was as per the prescribed limit, my lord. There was nothing poisoned here. The allegation of 123 that has been labeled against me. In fact, the medical test of the people who have said to have been consumed poison,
That
they-
is something else.
that is E. coli, that is a normal bacteria. That's
So this
different.
bacteria has come from your bungdal.
Maybe, my lord, but that's not, that cannot be contemplated as 123. That is a simple case of food poisoning which happens due to some food mishap. But
What is that mishap?
my lord, that may be anything, my lord, that may be,
Oh, that we should know. What is that anything?
but my lord, that does not leads to poisonous substance or toxin substance that would be fatal to the human body consumption, my lord. My lord, it may be to the air pollution, it may be the air dust or anything with the moong dal that has been there, my lord. In fact, the lower.
Yes, Mr. Professor. Poisoning, at least prima facie from this report, not there.
Intentional
Not there. So he has been, when were you arrested?
On 17th, my lord,
17,
9/2025. And my father, my lord, he has been 95 years old.
95 years old. You're a very
That's
obedient son.
Yes, my lord.
You'll go back and sit with your father.
My lord, that I am a farmer, my lord, and my 95 years old, my lord. He referred to AMCH.
And you continuously go with him.
Being the son, that
Only son.
only son, my lord, the foremost duty, my lord.
Now who is looking after when you are behind the bus?
The wife is there.
Wife is good,
My lord.
obedient daughter-in-law.
My lord,
So you
as-
can remain some more time behind the bus.
my lord, the life of a father is a 95 son that.
Allowed.
Much obliged, my lord.
Nothing is there. 275, 274 not attracted. My dear Superintendent.
May please your lordship. 482 application lordship in this charge sheet was.
Yes, madam, what is your instruction? Hmm. 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 They are not appeared. What is the material against the petitioner hearing? In addition to his phone being used, what is the further material you have? Yes.
Anticipatory bail is not maintainable in this.
Why?
NBW has been issued by the
Hmm.
and my lord. Final complaint, it was filed on my lord
2015, yes.
in their apprehension, lord, it pertains to to an order wherein an
What happened to the apprehended accused? He's still behind bars?
No, my
is
lord.
on bail.
No, no.
There are three
The
accused, my
carrier who carried the notes, he's on bail. And he is
lord.
one of that.
Continuing since my lord 2023.
Yes, madam.
My lord, in this case, 3 persons' name has been shown in the
Hmm.
charge sheet.
Hmm.
Among them, lordship, one person, he is, who carried the FICN, he was arrested, he is released on bail, he is appearing. And one person who instructed to carry the FICN,
Keep him shake.
Hakim Sheikh, he was arrested by CBI in other case, then by
Don't arrest him.
NIA, by the, I think Hyderabad police. He is still inside the jail and he is appearing online before the CBI court, lordship, and they have not issued someone or warrant to that person who is inside the jail.
Forget it. Now, what about you?
This person at no point of time during the investigation, my lord, he was not charged because I was this person.
But summons were issued to you. You are not traceable.
No, I was not at my home, lordship. I have categorically.
Where were you? Show me that.
I have.
Show me that.
I have mentioned in my petition, lordship.
Where?
Paragraph number 7.
Hmm.
So, my lord, only,
Okay, tell me from here.
lordship, one thing is there.
Ms. Nargis, tell me from this paragraph that where were you? That you were in such a place that notices could not be served on.
My brother was
You have-
arrested.
you
My,
have
my,
not-
my brother was arrested and phone was recorded. That person who carried
Miss,
the FIC.
I'm not
My-
concerned with anybody else other than the
Kindly-
Morasalem today.
Lordship, kindly allow me to submit that to that regard, my lord.
Okay,
All-
when you finish, you tell me.
But thing is that my brother was arrested. He used my phone. It is mentioned in the charge sheet. And my lord, if they needed this person at that particular point of time, they could serve a notice upon me. That time they have not served. They solicited the person. My brother at no point of time he has mentioned that I was also implicated in this case. He was appearing.
Where is your statement to that effect?
Eh,
Where is your statement that you were?
Where-
Yes, madam, now you have said, listen to me. In paragraph 7, where have you said that I was not in my house, I was in X place? That my brother who was charge sheeted has also not informed the matter to me. Where is your statement to that effect?
Paragraph number 4 also, my lord.
4 is nothing.
4 is the mobile. And only allegation against me used mobile, that mobile was used.
Sorry,
Lordship, I will satisfy to that regard, Lordship, if this is not maintainable or I have not.
no, not maintainable. I am on the merits of this case. Where have you said that you were not in your house?
Yes.
That is why the notice you were in X place. You have not said that. You have not even said that your brother has not informed you. You go and appear before the trial court. Now you know, go and appear.
My lord, I will appear, plus, kindly protect me to that
No,
regard.
that you file an application in accordance with law, the trial court will say. You have been unnecessarily delaying this matter.
I
For the last 5 years.
I'm not delaying my,
We are holding it. We'll hold it. You go.
in that case, I'm not pressing the petition, my lord.
Ms. S.K. Nargis, Learned Counsel for the petitioner. After attempting to argue the matter at some length, submits that she be permitted to withdraw the present bail application. Prayer accepted. Bail application stands dismissed on withdrawal. You just write your names down.
Obliged, my lord.
May I please?
You are for
Special, CM Vigilance, Lordship.
CM Vigilance.
Well, this petitioner, well, can we see the FIR at page
The
30?
departmental proceeding and criminal case with regard to the same two bridges, approach roads.
That department has exonerated me now.
Not exonerated you, one penalty, a very minor penalty has been.
Penalty has been because.
Yes, Mr.
Without going to CIDA, I cannot submit it.
Whatever materials are here on record, it's a case of documentary evidence.
Right, Lordship.
What custodial interrogation do you want? He is a government employee, no apprehension. He will appear before you. He appeared before you once, twice, and now again you have issued a notice.
No.
Not notice. He said that it's behind, you are behind him.
Yes, yes.
Mother, what is the fun of the petitioner going to Mr. Bora, disturbing him?
That's paragraph 5 from the pleading of.
Disturbing Mr. Bora, you know the result. So, we'll put conditions. We are allowing this.
Accused in the same case by this coordinate bench.
Who?
That Baldev Sinha.
Sure.
Lordship, I leave it to Lordship, but this is the fact.
Baldev Sinha.
The FIR name accused also. Page 36. He has also filed another anticipated bail application, which should be at Lordship,
It has not been
not
listed.
been listed. Copy served yesterday. From there, I came to notice.
I don't know who is he, my lord, but.
Baldev Sinha is there.
36.
He's the, I'll tell you. He's the assistant executive engineer of that division, wherein you were the in charge. Okay. Mr. Bora, we'll give you in trip. We'll not dispose it up. We'll give you in trip. But Mr. A.M. Bora, senior advocate, assisted by Mr. V.A. Chaudhary, Learned Counsel for the petition. Also heard Mr. P.P. Dotto, Learned Special Counsel,
Additional special public.
additional public prosecutor,
For CM, special vigilance.
for CM, bracketed special vigilance. Also, the present application has been instituted by the petitioner, praying for grant of pre-arrest bail in connection with Vigilance Police Station case number 1/2024, registered under section 120(b)/420/468/471/406/409 IPC, read with section 13 bracketed 1 bracketed A/13 bracketed 2 of the Prevention of Corruption Act 1988. Also, the materials brought on record reveal that the allegation leveled against the petitioner pertains to the manner in which the final bill of the contractor involved in the execution of PMGSY package number AS-13-261 relating to package number pertaining to construction of Anipur / NEC Road to Harinagar, NEC Road at Harinagar to Pubo Boruala, page 35. Along with construction of 2 numbers of RCC bridges, also, it is the allegation in the FIR that the petitioner herein had released to the contractor involved the final bill without the works of the said project being completed. Also, it is also noticed that the petitioner herein was subjected to a departmental proceeding on the same allegation, and the same, after inquiry, was closed with the imposition of a penalty of withholding of 1 increment with cumulative effect. Also, considering the materials available on record and the contentions made by the petitioner in the bail application, this court is of the view that the same is to be viewed in the light of the disclosures that would be available in the case diary. Accordingly, issue notice, call for the case diary. Also, considering the materials brought on record, this court is of the view that the petitioner herein at this stage is required to be released on interim pre-arrest bail. Also, accordingly, in the event of arrest of the petitioner, accordingly, the petitioner herein, in the event of his arrest, be released on pre-arrest bail of rupees, how much? 25,000 with 2 sureties of like amount to the satisfaction of the arresting authority, subject to the following condition. Petitioner shall appear before the normal condition. Raised it to list this matter again on. So, Bora, when? On 10/11/2025 for production of the case.
Deeply applied.
Please, let's proceed. Pass off. Emerson will appear after some time.
We'll have to call for the case diary here. Serious allegation.
allegations, man. All them.
It is a case wherein the police has opened a station in your house, literally.
For that purpose.
But, mister, you're not there in the case. Let Mr. Hussain come.
That's
Pre-arrest bail, my lord,
Which hunting?
section 9, my lord.
Which hunting? We'll call for the case diary.
My lord, on 29, along with AB, another AB is there. BA is there,
He is there.
29.
But Mr. A.I. Uddin, learned counsel for the petitioner, also heard Mr. M.P. Goswami, learned additional public prosecutor appearing for the state. Issue notice. Next, call for the case diary. Registered to list this matter again on
2910.
29/10/2020.
Along with BA number 3413.
Along with BA number 3413/2025, which arises from the same FIR.
In this case, madam, I have some objection regarding maintainability, so that I will.
That you
present
take it up on that
at
day.
that time.
Blood.
I believe. Fire, my lord, relevant portion at
So Goswami,
But
what do you say?
page. Madam. Page 4 of the petition. First, my lord, it was a. My lord.
No, I got it. I got it.
Police.
I got it. These are matters pertaining to document.
And thereafter, my lord, it was conducted.
Enquiry is nothing. It's just it's there in page 17.
Yes, my lord.
Locally inquired. That is to satisfy the requirement of your
After
BNSS.
Yes, because they're in the FIR, my lord. So, my lord, I pray for that. For that, and before
But we'll have to protect her. I'll protect her in this case. Till then. Yes.
Submissions may be required.
We see the money came, her categorical statement is money came after she demitted office. If that be so, how can she be held to be responsible for that? That's the only thing. That we will verify from the
Yes,
case that if find
yes,
that
it
no,
is.
the money had come before that. That's the end of the matter. I'll
That
specifically
is why
put,
I am saying that.
we only that much
But-
because she has made a categorical statement here that the allegation is 15 Finance Commission. Huh? She says that the money came only after I had demitted office. Para 5.
Pretext of only debt.
Only that. But Mr.
Thing is that, 2000, admittedly 2000.
Mr. Barmia, we are specifically on this statement of yours in para 5. We are granting you interim bail. Provided it comes out that it is false, you are in trouble. Want to change your mind? You change your mind now. That is that you are going to stick with that. I'm quoting that provision.
I am also adding, delay FIR also.
You have to forget delay FIR. This paragraph we are quoting. But Mr. A.M. Barmia, learned counsel for the petitioner, also heard Mr. M.P. Goswami, learned additional public prosecutor appearing for the state. So, the present interlocutory application has been instituted by the petitioner hearing, praying for grant of pre-arrest bail in connection with Hailakandi PS case number 89/2025 under section 61(2)(318)(4)/316(5) BNS. Also, the perusal of the FIR dated 29/7/2025 reveals that the petitioner hearing, who was the Gaon Panchayat president of Bhashadhara Bor Hailakandi Gaon Panchayat, was involved in misappropriation of the funds allocated to the Gram Panchayat under the 5th Finance Commission 2023-2024 untied funds. Also, the untied funds. Also, the petitioner in the present application in paragraph 5 has taken the following stand. A to A. There are page 6 and 7. Any extra query. Also, considering the said stand taken by the petitioner in the bail application, which reflects that the funds under the grants under the funds involved in the grants of the 15th Finance Commission was received by the Gaon Panchayat only after the completion of the tenure of the petitioner hearing, this court is of the considered view that the petitioner hearing would be required to be extended with the benefit of interim pre-arrest bail. The above position, however, is disputed by Mr. M.P. Goswami, learned additional public prosecutor, who submits that considering the nature of the allegations leveled against the petitioner hearing, any order granting bail to the petitioner be so passed by this court after perusal of the case diary. Also, I have heard the learned counsel for the parties. Also, in consideration of the contentions raised by the petitioner in the bail application, more particularly that so raised in para 5, extracted herein above, this court is of the considered view that the petitioner hearing be enlarged, be released on interim pre-arrest bail on furnishing a bond of rupees 25,000 along with 2 local sureties to the satisfaction of the arresting authority, subject to the following condition. Appear Koribo. Appear Koribo on when will you appear?
10 days, my lord.
No. Give me a date.
Not before my last.
The petitioner shall appear before the investigating officer on or before 4/11, no, on 4/11/2025. Also, failing which, with effect from 5/11/2025, the liberty granted to the petitioner by this court in the form of interim pre-arrest bail shall stand vacated. Baki condition kita lagai diba.
11th, my lord.
Registered to list this matter on 11/11/2025 for production of case.
Keep level.
Earlier I came for adjournment, your lordship.
On the prayer of Mr.
It's Ali.
M.H. Ali, Learned Counsel for the petitioner, who
That
Mr. M.H. Ali, Learned Counsel for the petitioner, submits that the arguing counsel, Mr. A. Khalik, has passed on, and the petitioners have engaged Mr. Z. Kamar, Learned
Z.
Senior
Khalik.
Counsel, in the matter. Accordingly, he prays that the matter be taken up on 28/10/2025. No further adjournment shall be granted in the matter.
Your lordship.
Mr. Talda, we will not have this today because it's not possible. On the prayer of the Learned Counsel for the parties, Madam, we cannot have this today because this bail and all together, it doesn't mix well. Registered to list this matter again on Thursday, Guridia.
Thursday I'll
30.
not be there.
Huh?
In the first week of November.
First week, okay. 4/11.
March 25th.
We have heard you all at length, so only slight, not this matter, other matter.
Yeah,
Other matter.
that.
Other.
22.
May please, lordship, this
Hmm.
matter was passed, by lordship, before which of vacation, my lord.
Yes, Mr. Das, how can we help you in this?
My lord. The entire, my lord,
This is the second offense.
second of which, my lord. But only the procedural matter, there are some lessons, my lord, on the part of the inquiry officer, my lord, in conduct, making the conducting in the house, my lord. The procedural issue was prepared before making the conducting the search, my lord. And this search was also made, my lord, without having this search warrant, my lord, issued by the competent authority, my lord. Yeah, how do you think the search list could be prepared before conducting the search, my lord, in the house, in the job house, my lord?
You mean to say that the materials were not recovered from your house?
My lord.
What is the evidence to that effect? What have you led? If it was not for the second offense, then I would not have.
But that last also last, so you. Only where they say the conviction is only for 3 months, my lord, and the petitioner was also behind the bar almost.
But now that you are a repeated offender,
My lord.
it creates a problem under that act. What is the evidence you want me to peruse?
Such evidence, my lord, there's PW. Sorry, my lord.
PW 3.
The independent witness, my lord.
Viren Saha,
Yes, my lord.
Viren Sharma.
Ken Sharma.
Yes. নাছিলো টিজাৰ লিষ্টত মই ডেম্পৰ বাহিৰত চহী কৰিছিলো অজিত গগৈ ঘৰৰ পৰা তেওঁৰ ডেম্প পাই ৭০ গজ আঁতৰত মই চিজন লিষ্টত what is that word?
My lord.
1, 2, 3, 4th line right hand side. এখন অন্য কাগজত চহী কৰিছিলো
three.
এইট হ'ব নেকি Little bit. Have you got that last word?
Well,
PW3, 1, 2, 3, fourth line. Last word.
এই সময়ত আর PFA
মই Caesar listত. Till talk, okay, what is that? Two other. এখন অন্য কাগজত চহী কৰিছিলো স্ক্ৰেপৰ দামৰ পৰা প্ৰায় 50 গজমান 10 গজমান আঁতৰত ৰেল
কাগজত সহি করেছিল স্ক্র্যাপ স্ক্র্যাপ ড্যাম্পর পৰা
প্ৰায়
প্রায় 10 গজ আঁতৰত ৰেলৰ
বস্তু পৰি
পৰি যোৱা মই দেখা পাইছিলো বস্তু অজিত গগৈৰ পৰা
হোৱা বুলি RPF লোকৰ
আৰপিএফৰ লোকৰ পৰা মই গম পাইছিলো
মই 20-22 বছৰ ধৰি
জানো
অজিতক জানো
অজিত গগৈক জানো
অজিত গগৈক জানো
এই আদালতত
অজি আদালতত
দেখা জন মোক বস্তু মোৰ
So there is nothing here. Any other evidence you want to? Oh, that is cross. Any other evidence you want to?
It's a PW9 malo. This is the only PW3 and 9 is a independent witness malo.
Let's see 9. Well, some আমাৰ গাঁও
The guy is a village admin malo.
অজিত গগৈ ঘৰত ডেম থকা বুলি মই RPF-ক এখন চাৰ্টিফিকেট দিছিলো উক্ত চাৰ্টিফিকেট প্ৰমাণ Okay. Yes, Mr. Dey. What do you say?
Only PW8 experts' opinion. Else, whatever the materials recovered from this
The railway.
railway material.
But whether how what is the railway had RPF have recovered it from his shop? Where is that material? The witness says that it was lying outside his shop. So where is that connecting that material that this is inside and it was brought outside?
Only Lordship, no neutral.
Nothing is there. You were arrested on 22/1/2009 and released on 3/2/2009. Right, Mr. Das?
Just like
Railway sector.
he was arrested on 22/1/2009 malo and released on 3/2/2009 malo. Then there is again malo on 2012-2010 bail was granted malo.
Then he was again behind bus.
That is actually I'm not sure malo. And on the 29th 2010 allowed to remain on previous bail.
On previous bail only.
And next measured by this bail order was passed by 14/3/2013, my lord, by the learned session judge, my lord, while the criminal appeal was filed, my lord.
Okay. We'll find out some way.
Only, my lord, actually, this is a case of 2013, my lord. After that, it's so long back, period of, my lord, almost 12 years. After 12 years, if the petitioner is again,
No, Dave, now that you have been convicted the second time, you are entitled to 5 years, but they have given you
3 months, my lord, 3 months.
to the time already spent.
That's it. Okay.
No imprisonment. No further imprisonment.
Period undergone, my lord.
Concurrent findings. So that much I can do for you.
Understood.
Obliged, Lordship.
Disposed of.
Okay, Mr. A.K. Gupta is on like
23. Oh, that case. As agreed to by the Learned Council for the parties, a registry to list this matter again on Undina Pariye 4/11/2025.
twice.
As agreed to by the Learned Council for the parties, none appears for the parties on call. For the ends of justice, registry to list this matter again on Kundina Pariye. 6/11/2025. This is Lakheswar Saike. He was in the railways, then came on deputation to FCI, right? He was in railways. He was a registry to list this matter before any other bench without me. Know him very nicely.
Can I pay a date, my
As Mr. Das has submitted that there is urgency in the matter, a registry to list this matter again on Wednesday, 29.
29, my lord.
29.
Bad blue.
Mr. Uddin,
Fine.
your bail order says that there are witnesses deposing against you.
No,
Yes, your bail order says, page
Yes.
37.
nobody has named me.
That's
Therefore,
it. But there is a disclosure here.
Yes, your lordship kindly, therefore I am for
The statements are not here. 161 statements are not here.
that.
The basis is they have filed
Page
this.
37.
Ah.
Page 37.
Perusal, third paragraph. Perusal of the case diary reveals that some witnesses have named some other person where the name of the petitioner is not.
Not
It's
in-
the other way around.
So this honorable get examine the my lord and immediately thereafter search sheet laid.
Yes, Mr. Sharma, what is
My
this
lord,
matter?
My lord, in the search sheet, my lord, kindly find, my lord, 25, my lord, page. So, during the course of investigation, my lord, the complicity of the present petitioner is, my lord, that is mentioned. And when
I
other
got
thing
it.
other
This
thing
is a corruption charge.
Hello.
Mere verbal, something has to be there
Yes.
connecting him.
A record will pose. And my lord, other thing is that, my lord, deputy commissioner
got
is the
this.
party. Deputy commissioner is the party, my lord. So notice may go.
See, it's a very laudable thing that you have done to weed out corruption, but you should do it in a manner known to law. Blanket allegation, corruption, then you go and make take.
My lord,
What is the connection? If somebody comes up and says that, oh, I have paid him 5,000, date, time, for what, how, these have to be brought on record.
It will in the record.
Record, we'll call for
Record will be
declaration.
called for, my
When
lord.
is the next date fixed, mister?
Next date, my lord, 29/10.
You take an adjournment on that day, we'll call for the records.
Yes, my lord. And my lord, the notice go to the
We'll go, we'll issue.
but to.
On behalf of two, my friend is, he is.
No, he can't appear, he can't appear.
Under his official capacity.
No, no, that is not the deputy commissioner. He's not for the deputy
Yes.
commissioner. Deputy commissioner is civil, he is criminal.
Then GA will appear.
Yes.
Anyway, you take steps. Heard Mr. Ayuddin, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional advocate, additional public prosecutor appearing for the state. The present application has been instituted, present petition has been instituted, praying for quashing of the proceedings in PRC case number 668/2022, arising out of arising out of Hosai Police Station case number 635 of 2021, bracket over under sections 120 bracketed B /406 /409 /420 /468 /471 IPC. Also, the materials brought on record reveal that the charge sheet in the matter has been laid by the police and the petitioner herein has been named as an accused therein. Also, in view of the above, issue notice registry to requisition a scanned copy of the trial court records. Petitioner to take steps for service of notice upon the respondent number 2 through the office of the senior government advocate, Assam, Guwahati High Court, steps within 2 working days.
Course of the trial date. Recently, I directed to the GA Assam, my lord, in course.
No, the senior government advocate Assam, office of the senior government advocate.
I will take a step in the cause list in the next time.
They registry to list this matter again on when?
The receipt of the record, my lord.
You will let us give it a time.
LCR.
On 3/11/2025 by reflecting the name of the government advocate Assam in the cause list.
I am obliged.
After some time,
Why?
Carol will appear on he is in.
Today would be difficult. So, Soma, have you gone through this?
Yeah, my lord, what do the petition, my lord? Then, my lord, kindly we have a look at
He
my lord, page
dates,
19.
the only thing his cases that Mr. Bhuya has projected here is that the theft is of 6/6/2021, right?
Yes.
And on that day, he was behind the bars, which he was detained on 23/5/2021. But your page 18, he seems to be the kingpin.
Yes, madam. That is why he is in jail, my lord, in connection with the same kind of.
Same kind of.
Same kind of offense.
We'll issue a notice here.
Yes, madam.
There is an urgency in
Oh, Mr. It is,
and it's fixed for evidence, Lord, against the order of the.
And the respond number.
sign B, 2 o'clock. What is this, Mr. Goswami?
Petition, my lord.
22, it was granted. Jimma was given. And in page 23, same authority, same thing, refused. That's the case.
Page 23, Lord,
I got it.
Yes.
But 22, you see, first, it was given nothing, no problem. And 23, that was rejected. Now, madam, what is the material to show that these mobiles belong to you? And what is the offense involved here? Why was it
302.
Huh?
At in-
302?
in-
And how are you connected with that?
There is, my lord. One car was also seized from, this car was already released.
No, no. What is the connection between you and the charge under 302? There has to be some connection so that we can understand why this mobile is required.
The report, this report annexed, it is 1 year back. So perhaps the investigation is,
No.
All
so a
Trial is
fresh
going
report
on.
can be, my lord.
Trial is going on. You are an accused in that trial. What is the allegation against you? Why is this mobile seized? That's what I want to know. How is it connected with 302, that offense constituting 302? You have your instructions on that. We'll take it up next week.
I will also file.
No, you give me that instruction. You get me that. On the prayer of Ms. P. Bora, register to list this matter again on 29/10/2025.
Oblige.
No report at this stage.
May, please. Your lordship can list impugn order at page 36.
Come to page 30, third paragraph.
Yes. The statement of witness in the middle part.
Harmonize so and so, that bold portion first. From Assam to, you are the person involved in running.
All that things, my lord.
And this order is of 28/2024.
Right.
The others are behind bars. You have not.
Others all, they have been enlarged on bail, my lord.
Okay, fine. You have not appeared before the court.
What happened, my lord? Your lordship kindly see the order dated, the impugn order at page 6/2/2025, which is at page 36.
You have been split up because you are not appearing. Your presence
Split
cannot
up,
be.
my lord, in regard to split up, I'll just whether section 62, whether allows it at all or not.
BNSS.
Lordship kindly see. No, CRPC, my lord.
CRPC.
That is only our grievance, my lord. I am
Okay.
ready to appear before the court, my lord.
62.
62.
Hmm.
Summons how served. Every summons shall be served by a police officer, subject to such rules. When officer of the court is other public servant, summons shall, if practicable, be served person summoned by delivering or tendering to him one summons. Every person on whom a summons is so served shall, if so required by the serving officer, regard to summon, my lord, not at all. Now, supposing summon is,
No, summons have been sent, it is not coming back.
if it is not coming back, then your lordship kindly see, the next course is 72.
70?
72. Warrant to be to whom directed. Now, after that, my lord, your lordship kindly see 82. Proclamation of persons absconding. Now, these are the, my lord, necessary thing to be complied with. Now, unless you do that, my lord, can he split it? Well, there is no such provision in civil.
We will examine. But Mr. S. Dr. Learned Counsel for the
One thing
Learned
is,
Senior.
only, Malad, he is a resident of Tripura. That was taken into consideration, Malad.
We'll consider, we'll only issue a notice. We are not staying the proceedings.
Or otherwise, your lordship can pass an order that he will appear before the court.
We need not. You go. You go and appear. How did you come to know when the order adverse to you has been passed, you rush to this court? Till that time, how did you come to know about this order?
Order, my lord, we have come
How?
from.
You don't know about the
from-
proceedings.
From the co-accused, my lord.
Co-accused. Why not before earlier you came to know?
And if your lordship look
That
at.
means you are you know the co-accused. Mr. Doctor, I'm sorry, I'm not
If you
entertaining this application.
Look at the charge sheet. My lord, these, the allegations are that. the
Whatever it
co-accused-
is, we are not on the merit of the charge today. We are on the conduct of yours.
That is, my lord, now they are saying that.
Now you are in Tripura. You don't know anything about the proceedings. Order of splitting has been passed. You rush to this court. Till now, you were not agreed. We will not allow this.
Writ of order is correct or not?
You appear before the court, take whatever orders are required. This court is not going to interfere in this matter.
Your lordship can observe.
We will not observe that also.
Regarding bail that.
You withdraw this, we'll give you liberty to go and approach, then as per law, they will consider the matter. Mr. S. Dotto, Learned Senior Counsel, assisted by Mr. S. Dotto, Learned Counsel for the petitioner, after attempting to argue the matter at some length, submits that he be permitted to withdraw the present petition with liberty to move before the Learned Trial Court. Also, prayer is not objected to by Mr. K.K. Parasar, Learned Counsel, Learned Additional Public Prosecutor appearing for the state. Also, in view of the above submission of the Learned Senior Counsel, the present criminal petition stands dismissed on withdrawal with liberty to the petitioner to approach the Learned Trial Court. Also,
The defense.
two advocates fighting,
Yes.
and the court is troubled with this matter for the last 5 years.
Petition in between, lordship. Two revision petition was there.
Nothing.
Both the revision petition, lordship dismissed. It is not against that is or not any other.
You go. You have been taking adjournments after adjournments.
That was the valid with valid reason, lordship. Because
It does. It may 5 years valid reason adjournments.
revision
But
petition.
Mr. M. Khan, Learned Counsel for the petitioner.
The next date is fixed on 29 for our.
We don't know. You get your notice served. Issue notice. Petitioner to take steps for service of notice upon the sole respondent by way of speed post. Petitioner is also permitted to take serve notice upon the sole respondent by way of dusty routed through the registry of this court. Full stop. Steps within.
Possible.
Then dusty to Katidia. Steps within 2 working days from today.
Some way protection.
A registry to list this matter again after 3 weeks on a date to be fixed by. These cases we are not. And you are an advocate. That is the ground.
Okay.
Yes, Mr. Uddin, what happened? And let him, he's done with you.
Respect to I check my, did he in fact maintainable? I will have to come under 226.
226. 15 to Lawson.
So I may be allowed to draw with liberty.
AB 2511.
Yes.
That which case?
Draw with hunting case. 48 is
Mr. A. Uddin, Learned Counsel for the petitioner, submits that he be permitted. He submits that the present bail application would not be maintainable, and accordingly he prays that he be permitted to withdraw the same. Prayer is not objected to by Mr. M.P. Goswami, Learned Additional Public Prosecutor appearing for the state. So accordingly, the present bail application stands dismissed on withdrawal.
party mality approach.
Part liberty you require.
I'm paying for adjournment for that limit.
Why?
Next week some other day.
Why? What is the problem?
Problem
What happened?
some difficulties.
What difficulty? Tell me. Difficulty with the court or your personal difficulty?
No, my lord, not with the court, my lord.
As prayed for by the Learned Counsel for the petitioner, registered to list this matter after 2 weeks on a date to be fixed by.
My lord, this BW has been issued against the present for his absence. But absence was with steps before the Learned ground.
And thereafter, there is no steps also.
No, my lord, because I am
Okay, what is your medical ground? Show me.
illness.
Where? What is that? Give me some material. You have not even produced that material before the Learned Trial Court.
On that trial.
But why? That was the main thing and that is the ground. Whatever may be, no.
Directly, Learned Trial Court cannot issue.
Forget it. The trial court has seen your conduct. Enough of that. The matters have been hanged up because of you. And they have said in para 10, page 25, the order dated 25/4/2025, there is nothing.
I've gone through, my lord. There are so
Then
many co-accused.
you
persons.
justify that. That is what you got
There
to.
are number of co-accused persons except.
I am only concerned about you now.
Correct.
Show me what is your ailment, how it prevented you even from advising your counsel.
He has taken steps, but that is the matter of record thereof.
No,
So-
that steps have not been taken.
There, no steps taken, my lord. Steps taken. There
I
are-
want to know the reason. Why? Continuously, you have never appeared.
Only, and the.
Continuously, you are.
At the preliminary stage.
I know that. But tell me now, your conduct is that your presence may not be secured in the trial.
I admit that. But,
Then go and
but-
surrender. Take whatever you want to do before the learned trial. This court is not coming.
till then, my lord, this important order.
We will not even touch that.
Kindly be straightforward.
We will not
Till-
touch
till-
that.
till
We
my
will not
appearance on
touch
next
that.
day.
I'm sorry, we will not touch it.
Till 17/11, my lord.
No, we are not touching
It
it.
is only limited prayer.
No, we are not touching it. We are not touching it.
Otherwise, it.
This conduct we are not accepting, Mr. Paul. You had your time in the sun, now go. Remain behind.
I am- I
The
am-
matter should be taken forward.
Exit also he can appear.
You can go and appear,
I am
make
ready to appear.
application, whatever it is.
Subjected to a limited interference of.
We will not even touch this, Mr. Counsel.
Kindly, my lord. I am no way connected with the offense.
That is a different thing altogether. That shows why you are not appearing. That again gives rise to an
To
apprehension.
dispose of it.
You go and appear. We'll dismiss this. When is the next date? 17/11. Much time is there. Go and appear before that. Take your plea before the tribunal. Withdraw it with liberty to appear.
Kindly.
I'll dismiss this. Choice is yours. If I dismiss it, it may be worse for you.
Our only contention on the point of law that no trial court can be given liberty to issue PW directly.
Okay.
When his appearance, learned counsel is present on behalf of an accused.
I'm sorry. Not accept.
Permitted, my lord, the court will be.
Show me that what is your ailment. Show me your ailment.
That is a matter of record of the learned.
No, that is nothing on record in the before the
No,
learned.
no, that is a matter of trial court record.
Then go and fight out before the trial court if you don't want to disclose before this
That's why
court.
I am praying before your lordship to dispose of it with a direction, with recording my submission that the.
Anything more? I'm dismissing it. Anything more?
Accused is ready to appear.
You are ready, you go and appear. Who is preventing you from appearing? Why do you require a prodding from this court? This conduct's not before this court. If you want to go and appear, go and appear. No problem. You want me to consider, I'll dismiss it. Today itself.
Lordship would want to decide what on merit.
What merit? I'll say that this
Because
is.
the provisions of NVW cannot be.
Yes, Mr. Bora.
Manner.
He is not appearing. Every day he is being filing permission. And lastly, the court found that he is being delaying the matter. The grounds is medical ground, no documents, nothing. It rejected. And then it has fixed the matter on 17/11 for appearance of all accused with their bail. Now he is before this court. I don't understand why.
There may be some due to illness, the accused may not
No,
be able to supply the.
Question is that there's
See.
summon.
Huh?
Warrant has not been issued.
No. Warrant has not been issued. No, warrant has been issued. Warrant has been issued. Warrant has been issued.
Warrant due to non-appearance.
Non-appearance warrant has been issued. But that has not been executed. NBW has been issued. No, he is coming against the order of a non-bailable warrant of arrest issued against so-and-so. Notice be issued to the bailer and submit a report. Fixings. And the court has said that there is no reason assigned. NBW. Proclamation attachment.
There are 10 page 25, my lord. What illness that is not specific.
Yes. With admit condition.
No, directly NBW was issued when they had not appeared.
Civil warrant.
The matter was committed to the Sessions
Session
Court.
Court.
Session Court then issued a summon. First Session Court, then
The committal court, if you lot.
Hmm.
Complied with. Then,
Complied with.
It has been
then it comes before the Sessions Court. First day absent. Consent prayers are allowed. Case record so and so is absent, are absent with steps. Accused so and so jewelers are present, file petition respectively, praying to stand so and so. Appearance. Accused are absent without steps, with steps. Second day also. Then 25-4. Absent with steps. From 22-11-2024, they have been only taking time.
steps has been taken.
Steps has been taken, but illness, no medicals or
No,
documents
sir.
submitted. Ground taken, today are illness, but what serious illness suffered by they are not sustained even by a single medical. Therefore, it is clear the accused persons are willfully defaulted only to delay further proceeding. Prayer of so and so rejected. Issue NBW. Is it mandatory that a bailable application has to bail warrant?
Formally, we lot the.
Formally,
the court-
but
Court what
Hmm.
he appeared. All this document at a 207 or the committal the appeared or he could not appear, but
is it fatal that if the court does not issue a bailable warrant?
no, it's not fact.
Not fatal.
fatal.
Not fatal.
It's
Because
not
here what happened is from the
Not
date the committal court fixed the matter,
Matters.
date before the trial court, these petitioners have never appeared. And every day it is illness. So the court has taken a
There
view.
is a judgment of this honorable court, my lord, which has been followed in number of cases.
Go ahead to Mr. Bora.
Proclamation 82-83 milots, the Nazrul Islam cases by H.N. Sharma is that 83 milot,
Ah.
that is regarding absconding milot.
Absconding.
Absconding, that 82, I know that H.N. Sharma, that one of proclamation and attachment when 82.
Here proclamation has not been issued against this
Not issued,
petitioner.
milord.
It is only NBW.
This case has not
Issued. Subsequently issued.
When?
At-
To the what?
Page
Where?
31, page 31. Last page.
Okay.
Then milord, if proclamation and
This will cover. No, proclamation has not been issued to you. No, issue reminder to so and so to execute NBWA issued against Tariful Islam
no.
and so notice. Mr.
Appearance of all the accused persons.
Your PA has not been issued against you.
No.
Report on proclamation. if you
Report-
take it.
The proclamation has not been
Not been issued. It's only in NBW.
issued.
Not
Because
issued.
A bail and report on proclamation.
Report on proclamation on Tarif, proclamation issued against your Tariful. Oh,
People, I am the current.
now what is this two things? Proclamation and also NBWA both.
After NBW proclamation, maybe.
When was proclamation issued against you?
on 38 or before that, it took 36. And annexer, sorry, page 28 and 29.
Here there is no proclamation issued against you.
Worship may kindly go to page 28 and 29.
Huh? Where?
29.
Tariful.
Tariful and tariful. And for execution, oh, yes.
Issued against.
No,
proclamation.
Sabi rule.
No. I am
Issue reminder to the concern for execution of NBWA issued against accused and Tariful and for execution of proclamation issued against Sabi rule.
Thereafter, my lord,
Huh.
last page 30.
Recall NBWA issued against Abdul. Proclamation issued against accused
31.
against Absalom. This is I don't find when it was issued.
31.
Issue reminder
Page 31,
consent
madam,
PS
last
for
page.
execution of NBW issued against so
Huh.
and so. And for execution of proclamation issued against accused Sabirul.
Huh.
Proclamation has been issued for Sabirul.
Sabi rule, but in the
Huh?
paragraph 8, page 31. Tariful. But I don't find this.
Or there is an 31,
Hmm.
page 31, para 8, proclamation issued against absconding accused Tariful Ali, so and notice to the bailer not yet returned.
But they I don't find a proclamation issued against him.
In the page,
Shown.
para 8 is
Hmm.
closed. Proclamation issued against
Tariful Ali.
Tariful
I
Ali.
am.
Speaks like that. Milan.
I think there is an error here. Because the earlier order, it is only NBWA.
But that is why there's not.
So what should this court do for him today?
Not appearing in the trial court.
Trial court.
But he takes steps. Now, a prayer of medical grounds is taking steps that I could not be appear. Now, there's no medical grounds. So, rejected. Not mandatory, exercise the power bailable warrant. Now, if they fail to procure his attendance, even then NBW,
Then proclamation.
then proclamations. No 80
Here
days.
it is straight away NBW, then proclamation.
Proclamations. That's what I don't know whether prior to that, because the order what I found, it's not in conformity, because in one order it says
That
issue proclamation.
we'll
against so and
confirm.
so.
We'll come because date is 17/11. We'll confirm that. But thank you, Mr. Bor. A. Paul, learned counsel for the petitioner, also heard Mr. K.K. Parasar, learned additional public prosecutor appearing for the state. Also, issue notice, issue notice, registry to requisition the trial court records. Also, scan copy of the trial court records. Registry to list this matter again on 7/11/2025, along with the scan copy of the
My
TR.
lord,
660. Okay.
published.
Okay, cool. Oh, Mr. He's come. Yes, ready.
With much difficulty he has come also.
He's a busy man.
Again, he will go, so many matters are there. By
He is the revenue of our High Court.
the boss, my lord. My lord,
Yes.
my submissions, although
Section 41.
I am new to the subject, my lord.
This is something new to me
My
also.
lord, what I am submitting for lordship, my lord, is the search was made in the year 2023. After that, my lord, the amount of 5 crores was determined. So that 2 crores from 25 lakhs was paid. Now in 2025, they have determined again the amount.
Hmm.
Includes the amount which was determined in the year 2023.
Hmm.
Now after that, it is mandatory that 41A notice with 35(3)
Mm.
has to be issued. If your lordship just look into it, 2-3 decisions, my lord, if your lordship.
Mm.
So let's move.
We'll just ask Mr. L. What about the notice under section 41 or 41A?
Section 70. Regarding agreement. Such procedure, I put, 23. No, copy. Copy इसमें कुछ बोले था copy.
This is for the year 23-24.
Your lordship may just see, my lord, my learned friends is saying, my lord, once
Under section 70,
has been issued and thereby necessity of issuing the notice under section
41.
41A, which is 35(3) doesn't rise. Your lordship may just look into, my lord, my compilation.
Hmm.
My compilation which has been given, my lord. Can you see
Page?
page 276? Very view.
Hmm.
At page 298, my lord. At 20.5.
Karnataka High Court.
My lord.
Para?
20.5, my lord. Therefore, in view of the above and the legal provisions of the right against vis-a-vis lack thereof at the stage of the inquiry, the primary purpose of which is ascertainment of the facts, I am of someone under section cannot be equated with the issuance of the Penal Act CRPC. The latter is issued at the stage of investigation when a formal accusation in the form of in the credible information or a reasonable suspicion exists to the commission of the cognizant so and so. Clause 70, your lordship is just similar. The 70 notice was issued, summons, my lord. The summons were issued, right to every notice
Hmm.
was determined at the year 2021 was determined. It's not so that I have not followed. And now your lordship is just 2-3 Ganesh Kumar and Satyendra, I will say, where the Supreme Court has gone to the effect that the disciplinary action should be taken against the police authority also if it is not complied with. Your lordship may just see, my lord, I will take your lordship, my lord. At page 65. The relevant part at page 71. Para 7.2, my lord.
71 of the
Compilation.
petition,
Judgment starts at page 65
of the compilation.
of the comparison.
Just a moment.
New, that's why I go through all this. Otherwise, your lordship knows everything.
I know everything.
7.2, my lord. Page 71, my lord. (7.2) and 7.3.
Page 70.
1. The law mandates the police officers of the state to state the facts and record
70?
1, my lord, 71. On the left hand side, it will-
Para?
7.2.
Okay, law mandates.
Law mandates
Hmm.
the police officers of the state.
This is Anesh Kumar.
Anesh Kumar. In fifth and substance, the police officers before arrest must put the question. This is your lordship aware. And the directions your lordship can see at page 70. 72.
Hmm.
Page 72. Your Lordship may see 11.4. The magistrate, while authorizing detention of the accused, shall produce the report furnished by the police officer in terms of the aforesaid only after recording the satisfactory magistrate shall authorize detention. 11.7, my lord. Failure to comply with the direction aforesaid shall, apart
Okay.
from rendering the police officer concerned liable for departmental action, they shall also be liable for punished for contempt of court for the to institute the High Court before the territorial jurisdiction. Then your Lordship can see, my lord, 11.8. Authorizing detention without recording the reasons of the aforesaid by the judicial magistrate concerned shall be liable to departmental action for the appropriate High Court. That is 41A, my lord. About that they are saying. Now, this same thing has been reiterated in Satyendra Kumar at page 173. The appropriate relevant part, my lord, at page 205. Paragraph 23, my lord. Or I may directly take to paragraph 25, my lord. The consequences of non-compliance, section 41 shall certainly inure to the benefits of the person suspected of offense. Resultantly, while the considering the application for enlargement of the bail, the courts will have to satisfy themselves on the due compliance of this provision. Any non-compliance would entitle the accused to the grant of bail. Now, my lord, my submission before your lordship is twofold, my lord.
Mm.
First, 2023, my lord, the search and seizure was made. 2025, my lord, again the notice has been issued. There is no allegation that from 23 to 25, I've done anything. Now, from 25, the figures which have been given, the amount figure, my lord, you'll also will note that in respect of two different firms, I'm a partner in both the firms, but the registered dealer is two different firms. Now, the taxes evaded of two different firms have been
club.
added together.
Mm.
Secondly, the amount which was determined earlier, out of which the 2 crore something was paid, that has also been included in toto without the reducing the payment. 2019-20 is time barred. That has also been included. If those amounts are reduced and the amount is taken to be separately, my lord, it will come to below 5 crores in both the cases.
Mr. Saraf, we need not go into if it is a case of violation of 41. We need not go into the other.
Pleasure was that, my lord, loss of reputation and humiliation that has been served. That has already been served. And, my lord, the business, as in Satyendra Singh, my lord, Anas Kumar, it has been said that what is the consequence of the arrest, humiliation. Your lordship wants to look into it, your lordship can you see the observations. Page 65.
Para 60, page 65.
The head note itself, your lordship can you see, page 66. Held. Arrest brings.
Humiliation, curtails freedom, so and so. So have we got it?
I mean, what benefit they are going to get me in judicial custody? And there is also a judgment, my lord, your lordship, just one more. Subject to your lordship permitting me, my lord.
Yes, yes, please.
My lord, at page 270. Element part at page 272. Paragraph 7, my lord. Last 4 lines below. The case of the prosecution rests on the documentary evidence. All the documentary evidence and the materials have been seized by the investigating agency. Therefore, presence of the present appellant does not appear to be necessary for our purpose of investigation. The trial is not likely to commence and conducting.
It's a documentary evidence, so whether custodial interrogation or custodial.
SLP was filed, my lord.
That was
SLP has been dismissed. Now, my lord, my submission for lordship that what their benefit will be that I must appear before them. Let them, by keeping me in judicial custody, how they're going to be benefited. If your lordship direct me that, my lord, for 1 month you remain in residence, don't come out. At least my reputation and humiliation that has been served, my lord, in the trial media, my lord, they are giving 87 crores tax evasion. Northeast, the biggest, my lord, that award has been given already to me. My lord, I will comply with whatever conditions your lordship wants to put in, my lord. And in your lordship may see, at least in Kent, it says this honorable court has granted the bail on the ground that for violation of 41, and I have enclosed all the orders.
It's here.
At least, my lordship may kindly, my lord, with,
Okay, now that we have taken up, we'll have to give a final consideration.
my lord, your lordship may just put whatever conditions your lordship wants to put. They want my statement recorded. Your lordship may put that whenever they call me, I will go there.
Like yesterday's that matter, we have
I
put
will
that condition.
Go there, they let them record the statement, whatever they want to record. They only want, my lord, I may say one thing, my lord. Your lordship, don't take it otherwise, my lord. They have become a god. If their blessings are there, he's out. If the blessings are not there, he's in. That may not be permitted, my lord.
Yes, Mr. KL, very serious submission. Forty-one.
To what?
No, section 70 notice apart, have you given him a section 41 notice, Taripat? But there are decisions which says that it is required.
Apparently, this point was considered honorable Supreme.
Show me. And tell me now, what is the requirement of his custodial interrogation? Everything is documentary here. And
Lordship, here.
this is nothing here. This is just the court said, go before
Yes,
the appropriate
no,
court.
Lord.
That's all.
Paragraph 15,
Nothing.
16.
These are just submissions.
Yes, Lordship. Lordship, what?
This does not lay down that
No,
the
Lordship, I'm.
two issues. One is section 41. We are not going into what you did not merit. This is not the appropriate moment. Second is, what is the necessity of a custodial integration when you have got determined everything finally and you have said that it is around 12 crores. That means you have got all the requisite materials with you. Maybe 87 crores, maybe 80 crores. That means you have come to that conclusion basing on the materials requisite for the purpose. Then, if that be so, what is the requirement of a custodial interrogation? Further, he'll appear before you whenever you call him. You proceed with the matter in accordance with law.
All says that.
And that will continue. But what is the necessity of putting this man behind the bars? You have no objection with regard to release of the petitioner.
Lordship, I'm.
But Mr. A. Saraf Lanat, counsel for the petitioner. The present application has been instituted. We'll record that. Why should
No,
we
Lordship.
go and write
No,
big
Lordship.
judgments?
My objection will remain.
What is your objection? You said that you have no objection in releasing the.
Compliance of section 41 not by BNSS. That is, we have already complied with all the.
Where is that notice?
Lordship, I've given the.
Where is that notice? Just find out that notice for me. 35 and 41.
41, Lordship, we have not mentioned. We have issued 70.
70.
Yes, Lord. In my submission, that is.
Okay. Section 70 notice. Summons. Suffice. Arrest is under section 69.
Yes. Tiga Agarwal, section 16 was.
We are not, we are only on section, Mr. Saraf is on section 41.
and summon issued to him on different. All these points were raised. All compliance was there.
My learned friend is so pressurizing, I may say, what the Supreme Court has said about the magistrates when the consider bail applications. Don't want to put all those.
Mr. Saraf, have some patience. Let Mr.
No, I'm saying that he said that it was rejected. That's why we are High Court.
Oh, that rejection is past. Today we are here, present. Anything more, Mr. What do you say about the second point, documentary evidence, the requirement? You say that the requisite materials against the petitioner has been collected, and on the basis that you have arrived at a final conclusion that this is the liability. So further, his custodial interrogation is not required. No. He'll come to you. He'll come to you. Whenever you call him, he'll come to you.
No, that is up to your lordship.
Okay. Anything more? We'll pass the orders. We'll pass the orders today itself. We are releasing him, but we'll put conditions.
Whatever conditions your lordship will.
Now Mr. KL is free to go.
Much difficulty we have to bring him because he'll be in other court.
My endeavor is to assist.
I know that. I know.
Wherever the case is there,
Wherever the back takes you.
is to assist all the. I may not only one court or two court.
Item 33 is a Jima of a car, my lord. I think my lord, record will be required as because it's an NDPS case. My lord. Can copy, my lord.
Heard Mr. NJ Dr. Leonard, counsel for the petitioner, also heard Mr. B. Sharma, Leonard, public prosecutor appearing for this day. Issue notice. Registry to call for the registry to requisition a scan copy of the trial court records. So, registry to list this matter again on when? How long does it take?
From Guwahati itself.
6:10. No, when should I list it?
November, Lordship.
November. On 6/11/2025.
Lordship, have a look at page 20, my lord. The impugned order, my lord.
This. Yes, Mr. Sharma. The counsel was there. He may have fallen ill. Situation may arise sometimes. He may not be in a position to cross. Otherwise, they are there. It's not that they have not done it. An opportunity should have been given to him. They are interfering with this order, requiring the trial court to give him an opportunity. Heard Mr. NJ Dr. Learned counsel for the petitioner, also heard Mr. B. Sharma, Learned counsel, Learned additional public prosecutor appearing for this day. The present petition has been instituted assailing the order dated 24/9/2025 passed by the Learned Special Judge bracketed Posco, Kamrup bracket Metro in special P bracketed P case number. It's called special P case number.
Yes, madam. 207.
207/2023, rejecting the prayer of the petitioner herein for deferring the cross-examination of the investigating officer and further proceeding to hold that the cross-examination of the said witness to be declined. So, as projected in the present petition, comma, the investigating officer was examined as a prosecution witness on 24/9/2025 in special bracketed P case number 207/2023. Also, upon conclusion of the examination of the said of the IO by the prosecution, comma, the the petitioner herein was to cross-examine him. Also, however, on account of the fact that the conducting counsel had to leave court on feeling unwell, comma, and petition was submitted in the matter, seeking adjournment. Also, in the said petition, it was highlighted that the conducting counsel was suffering from fever and jaundice. Also, the learned trial court took exception to the fact that the said application was filed after 2:20 p.m. and the investigating officer who had come in the morning was kept waiting. Also, the court also found variance with the ground taken in the application filed and the submissions made by the counsel attending in the matter, appearing in the matter. Also, basing on the said grounds, conclusions, the learned trial court, while order dated 24/9/2025, held that the ground sought for an adjournment in the matter was not satisfactory, and further, the prayer having been made at late hours, much after the conclusion of examination of the IO, comma, the prayer made for adjournment was rejected, and further, the cross-examination of the IO was treated as declined. Also, this court has perused the order dated 24/9/2025 as what I have heard the learned counsel for the parties, peruse the materials available on it. Also, this court finds that the defense was ready to cross-examine the investigating officer on 24/9/2025. However, on account of the sudden deterioration of the health condition of the conducting counsel, comma, a petition came to be filed in the matter, seeking an adjournment in the matter, seeking an adjournment. Also, the said situation as arising in the matter could not have been contemplated by the learned counsels appearing for the petitioner, for the petitioner hearing, comma, prior to the occasioning of the incident of the conducting counsel falling ill in the court premises itself. The court premises itself. Also, while it is a fact that the investigating officer who may have come to the court in the early hours of that day had to remain in the court premises on account of the fact that the conducting counsel had not come to carry out his cross-examination, and the application was filed only with much delay at around 2:20 p.m. on the same day. Also, however, noticing the ground raised in the said application, which is that the conducting counsel was taken ill during the course of the day while he was in court, this court is of the considered view that the direction of the learned trial court rejecting the prayer of the, the order dated 24/9/2025 passed by the Learned Trial Court, rejecting the prayer of the petitioner for an adjournment and holding the and further directing that the cross-examination of the witness was treated as declined by the defense. In the considered view of the court, has caused a prejudice to the interest of the petitioner herein. Also, considering the fact that no other ground has been cited for the said directions passed by the order dated 24/9/2025 by the Learned Trial Court, this court is of the considered view that the direction for rejection of the prayer of the petitioner for adjournment on 24/9/2025 and the further observation that the cross-examination of the witness is treated as declined would mandate an interference, and accordingly the same stands interfered. The Learned Trial petitioner is to approach the Learned Trial Court and file an appropriate application for recalling the investigating officer for the purpose of his cross-examination by the petitioner herein. So the Learned Trial Court, on receipt of such application, shall take necessary steps for recalling the investigating officer and for presenting him for cross-examination by the learned, by the petitioner herein. Also, the application be filed by the petitioner on or before 29/10/2025. Also, with the above observations and directions, the present present revision petition stands disposed of.
Deeply obliged.
May I please, Your Lordship? Your Lordship.
Mr. Bothakur,
Lordship.
what is the allegation against you during the commission of the offense by the that minor? Ayub, or what is his name?
Page 19, Your Lordship. Your Lordship.
Abul Hussain.
Abul Hussain.
What is the allegation against you?
Your Lordship, there is no allegation as such against us. Only allegation, Your Lordship will kindly see.
After that
They
incident,
have
you
come
had
for settlement. We did not, Your Lordship, enter into settlement, Your Lordship. Now the learned court below, Your Lordship, while taking cognizance, Your Lordship, has taken cognizance of all the offences, Your Lordship. It shows your non-application of mind, Your Lordship. On the face of the
POSCO section 21 can come in if you are involved in the commission or
Lordship.
leading to that.
Lordship.
Yes, Mr. Sharma.
6.
Have you gone through? The allegation is against Abul Hussain. He is a minor. He is before the juvenile board.
Lordship.
What is the allegation against them with regard to commission of that offense? I got it.
Everything. So let the records come, Lordship, because
Oh, I'm on that.
Yes,
But
Lordship.
basing on the materials available today,
materials, Lordship, because
FIR, charge sheet, nothing is there.
the conclusion will be wrong. They're not present. They were shown as absconder in charge sheet because they did not
The
participate.
informant is a party here.
Yes, Your Lordship. Now, Your Lordship, so far as that, Your Lordship, showing absconding, I have made a statement, Your Lordship, that we are all along there. They have not searched for us, Your Lordship, not issue. Notice was
Okay,
issued, Your
let us see the 161 statements, then come to a conclusion.
That's
The
a different
POSCO
matter.
being there has also to be substantiated by some allegation. And POSCO, after the act is committed, whatever takes place, POSCO will not come in. It will be the IPC. But here, I don't find anything with regard to POSCO.
And Your Lordship.
Yes, these three. It's charge sheet
As stated matter, Lordship.
Now, let's say the charge sheet.
Your Lordship,
Oh,
page 27, your Lordship.
something should be there. Page?
Page 27, your Lordship.
As stated, Lordship, there are statement of the victim.
That is what is not here. That is what we would
That
like
is-
to see.
Well,
Okay, heard Mr. S. Bhattakur, learned counsel for the petitioner, also heard Mr. B. Sharma, learned additional public prosecutor appearing for the state. Issue notice for registry to requisition scan copy of the trial court records. Full stop. How long will it take? 10 days.
Yes, Lordship.
Oh, full stop.
notice to the-
Petitioner to take steps for service of notice upon the respondent number 2 by speed post. Speed post? By way of the in accordance with the prevailing notification. Full stop. Steps within 2 working days from today. Register to requisition. Itu tar bishat likhibo.
Next date is 28th, your Lordship. Till that date, your Lordship.
No, we are not.
So your
not-
Lordship will kindly
that-
see your
that-
Lordship on the face of the FIR.
Nothing is going to happen. No evidences will be adduced on 28th.
No, but your Lordship, my appearance and
Do
everything.
appear.
So
We'll
your
see.
Lordship, kindly see, I have been shown absconder, your Lordship, will be put behind bar, your Lordship. That's why.
We will not do anything now.
At
We'll
least
see.
your Lordship may observe that, your Lordship, we will file a petition there, your Lordship. That's liberty to file a petition. Your
Register to list this matter. Your next date is 20?
28th, your Lordship, of this month.
Register to list this matter again on 3/11/2025. Full stop. The prayer for interim relief shall be considered upon receipt of the
Lord.
trial court records. Now, that will do.
Lords. Deeply obliged. Lord.
trial court record.
Why is the trial court records not coming? Seen the office note dated. Trial court record has come. Yet I have liquidated.
Appellate court recorded is.
Or criminal appeal. Trial court records requisition has not been received. Seen the office note dated
2210, Lordship.
22/10/2025, which reveals that the trial court records call for has not been, requisition has not been received. Registry to send a further reminder and ensure that the trial court records are placed along with the records of this case on the next date of listing. Registry to list this matter again on 3/11/2025.
Obliged.
Who is the special counsel here, Mr. Sharma? Range officer is a authorized officer.
For the state, my lord.
Okay, show me that.
Some wildlife protection rule 1990.
Not, ito no, the rule beleg is. What does it say?
It says, my lord. Nine, my lord, cognizance of offense, the following officers shall be authorized to make complaints under section 55, namely wildlife, chief wildlife warden, warden, any forest officer, not below the rank of forester. Not below the
Range
rank.
officer is above it.
Yes, above.
But 55 again says, no court shall take cognizance of any offense against this act on the complaint of any person other than director, member secretary, director, management, chief wildlife warden, or any other officer. Okay.
Any other.
Okay, any other officer. So, ma'am, that is gone.
Kindly come to page 36 of the 36 para 33 Lordship.
Hmm.
In their final complaint, they have stated that the divisional forest officer is the authorized officer under section 58 of the Wildlife Protection Act.
A confession made by the accused so and so, so and so.
Uh,
That is with regard to the confession made.
para 30
Now the filing can be done. Your case is 55 was violated.
55 was valid.
55 provisions of 55.
There is an interim
55
case.
B. B. Chief Wildlife Warden or any other officer authorized in this behalf by the state government. So they says that there is a rule which
Authorized.
forester authority less than the forester is empowered. Range officer is above the forester. Range officer is below
So,
forester. No, madam.
divisional forest officer is the
No.
My lord, this is.
Madam, there is a rule. This is under this
Yes, my lord. Under
55.
if I. My lord, kindly see.
The following officer shall be authorized to make complaints under section 55. Not below the rank of forester. Madam, have you gone through these rules? 1997. Go through that.
There is an interim order dated 37/2020.
Passed by this court. Okay, if you are taking up, we'll finally consider it. You make your submissions.
Lordship,
30? 30? Order, interim order?
37/25. Kindly come to para 3 Lordship. Para 6 on this aspect, the petitioner counsel submitted.
Madam, this is the ground that you have taken under section 55 and authorized officer has not filed the complaint.
Yes, Lordship.
I have shown you 55B, which empowers the state government to make rules. Rules have been made, and under 55, an officer above the forest officer is entitled to file a complaint. The complaint has been filed by a range officer. He is above the forester.
Forest.
So there is nothing here. Your this ground goes. So this interim order we will have to vacate. Then, on the prayer of the learned counsel for the parties, a petitioner raised it to list this matter again after 2 weeks on a date on 28/9/2025. It is to be noted that Mr. B. Sharma, Special Public Prosecutor, Wildlife, has submitted that the state government has made rules. State government under the provisions of Rule 69 of the Assam Wildlife Protection Rules 1997 has empowered, amongst others, forest officer not below the rank of forester to file a complaint under section 55 of the Wildlife Protection Act 1972. He submits that in view of the above position, the interim directions passed by this court would mandate to be vacated. So, however, on the prayer of the learned counsel for the petitioner, the matter stands adjourned till 28/10/2025. Interim order to continue till the next date of listing. To continue, submission of a Page 41, index of
However, this Lordship, before delving more, Lordship, kindly have a look
You're the husband,
at the wife. Lordship.
wife.
look like the definition of share household, Lordship. Two, Lordship. Act, Lordship, section 2S, share household. May I read, Lordship?
The court has given you directed for a shared rental house. Section of women's from. Yes, what is the error here?
Kindly.
You have a, Mr. Bowman, you have a copy, DV Act? Nigeria, Rani, 21. Yes.
Section 2, subsection S, Lordship. A household means a household where the person aggrieved lives or at any stage has lived in a domestic relationship, either singly or along with the respondent, and includes such a household, whether owned or tenanted, either jointly by the aggrieved person and the respondent, or owned or tenanted by either of them, in respect of which either the aggrieved person or the respondent, or both jointly or singly have any right, title, interest, or equity, includes such a household, which may belong to joint family of which the respondent is a member, irrespective of whether the respondent or the aggrieved person has any right, title, interest in the share household. Now come to kindly section 17, Lordship. Fact. Lordship. Right to reside in the share household. Not non-obstant clause, Lordship. Notwithstanding anything contained in any other law, for a time being in force, every woman in a domestic relationship shall have the right to reside in the share household, whether or not she has any right, title.
But here the conclusion of the court is that yes, you have a right, but putting you there would lead to the dispute being aggravated. So you have been directed to be kept in a rented house with the same facilities. What is the error?
For the legislative mandate, Lordship, I must.
Where is that legislature? It should be only in the house itself, no other place.
Definition, Lordship, must have lived.
That is with regard to share household. It does not say that even if there is a dispute, there is a risk, still you will have to be put in the house. The rented accommodation can also be given. Where is the bar?
What from this law?
Where is the trial court order?
Annex 4, Lordship, page 29.
Yes.
It is the section 440 of BNSS, Lordship.
Yeah, fine. Whatever. They have filed an appeal.
They filed a criminal revision. What additional session judge and modified by the learned additional session judge. But section 440 of subclause 3, Lordship, where any application for revision is made by or on behalf of any person before the session judge, the decision of the session judge thereon in relation to such person shall be final, Lordship.
So an appeal would lie.
No further proceeding by of revision at the instance of such person shall be entertained by the High Court or any other court, Lordship. Yes, Lordship, that means, Lordship, the decision of the additional session judge is final, Lordship.
Yes.
Because-
What do you say about maintainability?
Circumstances.
Maintainability.
Elaborate section, para 7, Lordship. Para 7. Petition.
I think this is a valid order. Para?
Para, my explanation, para 7, Lordship.
basic thing is that lordship, both the was never got married with lordship. The basis of a agreement lordship, the petition tried to harass the opposite parties lordship in this case.
Mr. I'm not satisfied. Right order passed.
Really come to in lordship. Then protection officer as well as the magistrate should encourage and
These are all sermons. We are concerned with the facts of the particular case first. Not but. So should I close it?
Lordship, kindly peruse the.
On the prayer of the learned counsel for the petitioner, raised it to list this matter again on 17/11/2025.
Lordship,
I'm not passing any order, but it's not harming you.
Lordship, I filed a separate criminal also, Lordship. But
Along with,
with criminal revision filing number H788/2025.
along with criminal revision filing number
H788/2025.
8788
2025.
2025,
Along with
filed by the respondent herein.
a criminal lordship also.
That will come together.
9/2025. Lordship.
So Chaudhary, you are appearing for the informant. So Biswas, we proceed further. You are challenging the charge sheet.
Yes.
There is materials.
307 T26.
Either as it may, there is materials against that, which would show that the commission of the offense. You had filed for a bail before this court, rejected. Supreme Court rejected. Finding materials against you. Why should we, on the basis, I have a very limited scope when it comes to challenge. And if I find that there is material just to proceed against you or indicate commission of the offense by you, the charge sheet cannot be quashed.
I'm not saying that all sections could be quashed. I pray that C26.
That charge has been framed against you.
Yes. No.
You argued the matter during the charge framing for discharge.
Meanwhile, my lord,
That is possible, Mr. Chaudhary.
meanwhile, learned session.
When the charge is being framed, he can always argue for discharge under those two.
Yes.
Why this?
Meanwhile. My lord, only
This court had held there was direct evidence against you in the matter. Matter was reiterated by the Supreme Court. Now you want a puny judge like me to question the wisdom of the Supreme Court?
to withdraw the petition, madam. I've given the liberty.
No liberty is required. Mr. S.T. Biswas, learned counsel for the petition.
Why do we? Meanwhile, learned session judge has given an opinion. These injuries are not life-threatening.
Fine, you go make your arguments there. Get it finished off.
This is the opinion of the session court.
Go back. Heard Mr. S.C. Biswas, learned counsel for the petition. Also heard Mr. B.M. Chaudhary, learned counsel, appearing for the informant. And Mr. M.P. Goswami, learned additional public prosecutor, appearing for the state. Mr. S.C. Biswas, after attempting to argue the matter at some length, submits on instruction that he be permitted to withdraw the present criminal petition. Also, prayer accepted. Prayer accepted. The present criminal petition stands dismissed on withdrawal.
My lord, I was granted interim bail, my lord. The ground of not issuing of notice under 35(3) of BNSS what is 41A earlier CRPC, my lord.
Yes, got your case diary. That is the only thing we got to see.
Only thing, only see that, only on the face of it, my lord, if your lordship kindly see, registered on, the case was registered on 9/7, arrested on 10.
Yes, got your case diary. Only thing we got to see is whether this statement that 41 notice was issued. That's all. When? Heard Mr. P. Bora, learned senior counsel appearing for the petitioner. Also heard Mr. K.K. Parasa, learned counsel appearing, learned additional public prosecutor. Mr. Parasa submits that the case diary is not received and prays that he would produce the same on the next date of listing. As prayed for by Mr. K.K. Parasa, registered to list this matter again on. When, Mr. Bora? 11/11/2025. Interim order pass. Any
7th, my lord, 7.
7, Friday, 7, okay, 7/11/2025. Interim order passed earlier to continue till the next returnable date.
Obligement.
May I please, lordship?
How long have you been in? When were you arrested? When were you arrested? What do you want to say? Adjournment. CD receipt. Oh, LCR, TCR has come. TCR has come. I think 2 witnesses have been, the victim and the mother. Mother has been. Not a very good conduct, headmaster. On the prayer of the learned counsel for the petitioner, matter stands adjourned, registered to list this matter on 17/11/2025. 17/11. Want it earlier? When? Want it earlier? No, 17 is fine with you. 7 November. Instruction of your senior, we are accepting 7 November. And if you have instruction received from your senior, make it a point to tell it to the court. Get my point? Don't be afraid in a court. You are bold. Yes.
Item 45, senior counsel H.R.S. Chaudhary will be appear, my lord, taken up.
Grounds CD received.
But also there is some submission, lordship, because that is AB. That is why he instructed me.
Which one? 43 AB. Rape 14/9. Rajivuddin. So it's on the same FIR.
Same FIR. That is why lordship take it. Lordship add 2 lordship.
NDPS. What is next round of material? Yes, Mr. Monto, what are you waiting for? 47, 48, there. CD, receipt. Two. That bank robbery.
Bank, my lord, I make my submission, my lord, probably.
Well, we'll see. Only thing, see, whether the allegation against the petitioners is based on the co-accused, if that is the only ground, maybe what is the material available against them, branch manager and the cashier?
Yes, yeah.
With regard to this same. And also see as to the persons who were there in the afternoon when the thing was locked. And why did you lock the bank and go out
My
at?
lord, actually, my lord, what happened, that they are in that bank only 3 persons, my lord.
Oh.
So these 2 person, my lord, when they are going, my lord, it is a common.
And where is that? Where was that?
No circuit, there nothing, my lord. There is no sentry and nothing, my lord.
And
Only
the
3 persons.
cutting of the locks
Lock, my lord, that means
is of the main door or of the strong room?
strong room, my lord. He was in.
So,
He was there, my lord. That food grain employee was there, my lord.
no, he was not there.
The main door, sorry, main door, my lord.
That you check up.
And no law.
Whether it is of the main door or the thing.
21.
No, if there is nothing against them,
And then money has been recovered.
recovered means you kept the money hidden. 54,000 from the,
Yes, from the house of the Fort Gate. No, on the basis of the co-accused statement, all of it is, my lord, no evidence at all right now, my lord.
let him go through. 2 o'clock we'll take it up. How to nego? Fine, eh? 2 hours. Along with bail application number 3121/2025. To me, BA 3121/2025 would lihiba. List this matter on 31/10/2025 along with AB number 1964/2025. The door. Yes.
Anticipatory bail application. The petitioner here is the wife of the main accused, my lord.
And you are absconding from your house after the incident. And the police has opened a police station in your house.
Yes, my lord. Thereafter, a petition was filed, my lord.
Get the case diary.
Interim protection may be given.
No interim protection.
There is nothing in.
No, there is nothing. Your conduct shows. We'll see. We'll see.
Short date may be given, my lord. then.
Short date, subject to the production of the case diary. Heard Mr. M.A.I. Khan.
M.A.I. Hussain.
M.A.I. Hussain, learned counsel for the petition. Also heard Mr. B. Sharma, learned additional public prosecutor appearing for the state. Issue notice, call for the case diary. Mr. Sharma shall produce the case diary on the next date of listing. Registry to list this matter again on 6/11/2025 for production of the case diary. Yes, Mr. Ali.
Please, your lord. The married woman having 2 children, 30 is, my lord, 30 years. Develop love affairs with the.
Fine, I got it. Where were you during the period of investigation?
Lord, he was not, my lord, charged by the police, my lord.
No, you have not taken a bail also here.
No.
No. And cognizance, a summons have been issued to you.
My lord,
11/7/2024. What happened thereafter?
7/7 for appearance.
What happened after that?
And next date is on, my lord, 3/12.
3/12. What happened after 11/7?
Has not appeared, my lord.
Whether summons were served?
But summons, my lord, because he filed this petition, my lord. So he.
Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Issue notice. Also, petitioner, Mr. Sharma accepts notice on behalf of respondent number 1. Petitioner to take steps for service of notice upon respondent number 2 by way of speed post. Also, steps within 2 working days from today. Registry to requisition the trial court records. Also, trial court records. Also, registry to list this matter again on
Some time.
on 10,
Yes, 10th.
on 12/11/2025. We'll see. Let the records come. Trial court records along with the case diary. We'll see. Let the records come, we'll see. Yes, yes, Mr. Parasar, what did you get?
At that, on that day, morning time, the cashier came. Subsequently, at around 2 to 3 lunchtime, around 1 p.m., manager asked her that Shakala or Yanjan, how to, whether you can cut the lock. And
This is from the statement of Aryan.
Yes, Oriental. And subsequently, in details, 4 pages statement, Malad may peruse. He went to his house in upper stair of his house on that. There was some tiles making work is going on, and using that machines, he sends the blade, rod cutter blade. He has sends the blade, and that cut that lock.
Cut the lock of which lock?
Lock
Main
of
gate.
that
Gate, man.
gate.
Main gate.
It is in the FIR also. actually.
But subsequently, the dust coming out from that cutting, he clean it, and subsequently the manager and cashier together, they both got those amount of money and kept in the storeroom. Now they all around 2, they all went out. Before at 2:55, first that person came, and as per the plan, told the manager that lock is found broken and all this.
Senior manager.
Now CCTV footage are also there. Police has collected, and Malat investigation is a very initial stage.
No, what happened to what do you get from the CCTV footage?
The footage analysis details are not
We want that. We only want to know the modus operandi. If the petitioners were there, were seen to be shifting the money, if you have material, then it is a serious thing.
9 lakh something that was found in the storeroom.
Storeroom, 54,000 in the house of the.
Yes. And other 3 lakhs and something all in the case.
Cash.
Something in the case, yeah. Now both plan done by the manager, cashier, both are involved, and these are the 3 persons, my lord. Now investigation and the statements of that mystery and all these, my lord, they found that the machine blade is yes. He asked the father of that.
So you mean to say that the doors lock was cut before 2 o'clock?
Before 2 o'clock. Before 2 o'clock. In presence, before 2 o'clock, the cut the lock.
And the CCTV cameras are inside the premises or outside?
Inside the premises also, but once that statement is there that to some portion that CCTV was not there, because at that morning time there is no light, but the research was not there. So he made 1,000 research, then the light came. So, but at the time of the incident, perhaps the CCTV is there. There is 2 pen drive collected by the IO in the
pen drive for what? Of what?
Maybe on the CCTV, but the details is not.
Get that details.
Necessary.
Only thing is that if their presence is, all the 3 presence are shown towards the storeroom, taking the money before 2 o'clock, then there would be some culpability.
No.
Otherwise,
Except the statement of the, my lord, that Bulu, other evidence, my lord, what is your lordship kindly say?
no other evidence, they are now, there cannot be any other evidence now, Mr.
My lord.
The only thing now we have is the CCTV footage. If the CCTV footage is revealing something,
Then, yes.
then fine. We'll wait for how many time? We'll give you a week's time. You get that details. I heard Mr. T.J. Monto, Learned Counsel for the petitioner. As senior counsel appearing for the petitioner, assisted by Mr. D. Monto, heard Mr. T.J. Monto, Learned Senior Counsel, assisted by Mr. D. Monto, Learned Counsel for the petitioner. Also heard Mr. K.K. Parasar, learned counsel appearing for the, learned additional public prosecutor appearing for the state. Mr. Parasar submits that the case diary as received reveals incriminating materials being, reveals that materials have been brought against the present petitioner. Also, Mr. Parasar submits the premises was covered by CCTV surveillance and an analysis thereof is pending. He prays that he be given a week's time to update the case diary and include therein the analysis report of the CCTV surveillance as available inside the bank premises. First, in view of the above, case diary be written and an updated case diary along with the disclosures made from the CCTV surveillance available inside the bank premises be incorporated and placed before this court on the next date of listing. Registry to list this matter again on 10th will be too much. 6th. 6/11/2025.
Sir, because of this.
Huh?
Sir, because of that,
One cut,
South
sir.
Salman.
7/11/2025. Next to same order.
Same.
Beleg.
Same.
Same. Khali beleg order my same order to Arebar my 7/11. Otherwise, if it is only the statement of the co-accused, they'll have to,
That
but
is
there
hereby
has to be something more. And also see, the money is to be kept in the strong room. And if they have to take out the money from the strong room, the cashier and the branch manager have to sign whether they had taken the money out of the strong room on that day, because this money cannot be left outside. Strong room, the man cannot go in. Strong room, only from where this money was kept in the storeroom, 12 lakhs. Cashier's drawer. Find out how the money was taken out at 10:30, because 10:30 when the bank opens, they go, they have a form, they sign
They
there.
have to.
They signed there that
Big
this much money has been taken out from the, find out in that direction. If it is found that 12 lakhs is there and he cannot explain why that 12 lakhs as a whole was kept. If there is a, say somebody had requisition that we want 10 lakhs. So he'll keep the money, take out the money, keep it. Otherwise 12 lakhs is not kept in a bank. So try to do it in that direction. Then we can know whether the two are involved or not. Commercial quantity.
Yes, my lord.
Yes, case diary has come. Rashid has been filed. Yes, you appear. Heard Mr.
PR does, my lord.
PR Das, Learned
BR.
Counsel for the petitioner. Also heard Miss P. Upadhyay.
M. Deca.
M. Deca, Learned Counsel appearing for the NCB. Also, the present bail application has been instituted by the petitioner Salma Khatun, praying for grant of regular bail in connection with NCB case number 06/2025 under section 8 bracketed C /22 bracketed C /29 NDPS Act. Also, during the deliberations, the Learned Counsel for the respondent NCP has submitted that the charge sheet, that on conclusion of the investigation, charge sheet has been filed on
1710, not
17/10/2025. Also, in view of the above, the petitioner herein is granted liberty to approach the Learned Trial Court and for Learned Trial Court and Learned Trial Court for regular bail. Full stop. In the event the petitioner approaches the Learned Trial Court, the Learned Trial Court shall consider Learned Trial Court by filing an application for being enlarged on bail. The Learned Trial Court shall consider the same in accordance with law.
There is two petitions.
Two. Salma Khatun and
Gita Bibi.
petitioners they. And Gita Bibi.
Yes.
May please, your lord.
Have you filed an affidavit? When did you file it? Paper publication.
Yes, your lord.
When did you file it? Okay, okay. Why not in the English daily? Two dailies have to be published.
The complaint was fixed.
So you will have to file it in some alternatively some paper. Which one? You find out. I'll say something, it will be another 14,000. You will not be in a position. You find out. You are Mr.
MJ Hazari.
MJ Hazarika, London Council for the petitioner, submits that the matter be taken up on 30/10/2025 so as to enable him to receive instructions with regard to the paper in English paper in which the advertisement notice is to be published.
So, during last postal
Can't help it. That's why the paper publication,
direct the registry to like
paper publication. You give me which paper. None appears for the petition on call. Registry, however, for the ends of justice, registry to list this matter again after 2 weeks on a date to its date. Yes, Mr. Doctor.
On FSL report, man.
Sorry, I think.
Oh, man, 55, I'm sorry, man.
54. Yes.
Okay, so
It is not received. Notices were issued on 28/8 itself. Nobody has received. See now CBI will why this is required. Also, this is for orders. Also, as prayed for by the Learned Council for the parties registered to list this matter again when? Tell me for admissions. November, first week starts from 3rd, 4, 5, 6, 7. 5 is a holiday. When do you want it? 7. 7. Madam, you are here on 7th. 7/11/2025 for admissions.
And request our
Ah.
time being probably
No, ma'am, we have just, because today it not be possible also, we have just fixed it on 6/4.
absence has been shown.
Oh, it would, item number 61 to 65. None appears for the petitioner. However, ma'am, heard the Learned Council for the parties liquid, yeah. As agreed, registry to list this matter again on 6/11. 6/11 is 7/11. 7/11. Huh?
Filed our short synopsis. Yeah. Much obliged.
FSL.
FSL, man, this one.
Heard Mr. M. Dr. Learned.
The respondent.
It is REJJ. Where do I get it from the document?
Page 103, my lord.
Last page. First, my lord.
Page 107, my lord.
Just a moment. Where do I get it? Here?
71, my lord. In the first, my lord, after the, my lord, heading, my lord. After the heading, it is memo number. After the memo number.
Three 71 is a communication dated 22/2/2004.
Yes,
Abdur
after
Razak.
that name, my lord. That
Okay.
name.
Mr.
Well corrected, my lord.
Mr. M. Dr. Learned Counsel for the petitioner prays that he be permitted that he would file an interlocutory application for correction of the name of the respondent number 2 as incorporated in the present criminal petition. So, Mr. MP Goswami, Learned Counsel, Learned Additional Public Prosecutor, submits that the FSL report as directed to be produced by this court has not been received by him. He prays that the matter be taken up on
15 days, my lord, at least, my lord.
Give me a date.
Yes, my lord. On 20th November
20/11/2022, on which date he shall endeavor to produce the said FSL report. Also, in the meanwhile, the petitioner may file the interlocutory application for correction of the name of the respondent number 2. Because
obliged.
title, huh?
Yeah.
Lordship, yes, ma'am.
Item number 50. File any there and parawise reply. So I may be given
54 would, yeah. Liberty is granted to the respondent to file a response if so advised.
Item, my lord. Appeal and suspension, my lord. Appeal has already been admitted. I'm sorry, my lord.
We have passed it. We'll take it up. When Kiman issue? 1 week, good, yeah.
Next week, my lord, any date.
1 week. Mr. Non-APS Asana, Mr. Had Mr. S. Bishwas, Learned Legal Aid Counsel. As agreed to by the parties, registered to list.
We would like to publish in the Notice Times, the notice.
Next date, not today. Next date.
Please, your lordship. This revision is against the conviction. It is the appellate judgment confirming the conviction. That modification. There was convicted Sociable Instrument Act. Sentence of payment of 4 lakhs and default 4-month sentence. The appellate court lordship, it was reduced and modified of payment to 3 lakhs rupees and all that 4 months. In the meantime, lordship, sentence was executed. I was put behind the bar on 8 August 2020. Now, lordship, I am before your lordship. A delay condemnation petition for the condemnation of delay
Your period of detention is already over.
about to over. Lordship, the delay that the entire appeal would be in fact, sir.
My purpose is will not be
Paid the boss. You want him out? Do you want him the money to
money
be
to
paid?
be paid.
When were you put behind boss?
8 of August 2025.
Fault.
Yes.
interlocutory application bracketed criminal number 998/2025. Heard Mr. P.P. Dotto, learned counsel for the petitioner. Also heard Mr. S. Bhattacharya, learned counsel appearing for the respondent number 2. Upor Likhiba also heard Mr. MP Goswami, learned additional public prosecutor appearing for the state respondent. You have no objection in condoning the delay.
Not record it, your lordship.
Also, the instant application has been instituted praying for condonation of delay of 364 days in instituting the connected revision petition assailing the judgment and order dated 7/6/2024 passed in criminal appeal case number 36/4/2023. Judgment and order dated 7/6/2024 passed by the learned district and session judge North Lakhimpur in criminal appeal number 36/4/4/2023 upholding the conviction of the applicant herein by the learned judicial magistrate first class North Lakhimpur wide judgment dated 19/9/2023 passed in CR bracketed NI bracket over case number 28/2017. Also, I have heard the learned counsel for the parties. Also, on a perusal of the contentions raised by the applicant in the present interlocutory application, it is seen that the what is your delay? What is the explanation?
Page paragraph 4 and 5, Lordship. Page 6. Financial constraint, Lordship.
Wakil Hijau? By the learned, by the applicant. In the interrogative application, it is seen that the applicant was trying to arrange for the money for payment to the complainant, respondent number 2. So, however, he and as he was willing to settle the matter with the respondent number 2. So, however, he submits that he being placed under arrest on 8/8/2025, he was prevented from approaching this court earlier. The applicant has further submitted that he has paid an amount of rupees 1 lakh to the respondent number 2. 1 lakh is paid. Then what is left here? You have agreed everything. Now you have to pay him. We'll allow it. You pay him. We'll pay him. Within 15 days, you pay the money.
Our petition will be numbered. Acting bail and as well as the appeal yet to be numbered.
I'll do it everything in one go.
Lordship.
You pay him. He is interested with this. Okay. Full stop. The contentions raised by the learned counsel for the parties have learned counsel for the respondent had submitted that the grounds assigned by the reasons assigned by the applicant in the present interlocutory application for justifying the delay occasioning in filing the connected revision petition does not inspire confidence and would not mandate acceptance. Also, I've considered the submissions of the learned counsel for the on a perusal of the reasons as assigned by the petitioner in the assigned by the applicant in the interlocutory application, although the same is not found to be satisfactory. However, considering the nature of the offense and the nature of the offense alleged against the petitioner and the willingness of the petitioner herein to settle the matter, this court considered it appropriate to condone the delay of 364 days in preferring the connected revision petition. Accordingly, the delay of 364 days stands condoned. The 64 days in filing the connected revision petition stands condoned. The present interlocutory application stands allowed. Full stop. A baki criminal appeal of Likiba, registry to, in view of the order passed today in I bracketed criminal 998/2025, registry to register the present revision petition and list the same on 29/10/2025,
I have for such.
along with the connected interlocutory pending interlocutory applications. Yeah, that will, on that day we will, you come up, how many days you will pay, we'll do that and we'll finish it up.
For that lordship, that applicant will have to be come out from the jail.
Oh, you ask your applicant, we'll do it in one go. Today it's not that.
Application is
This
inside-
court is 786, but today
Yes,
it's
sir.
AI. Ah.
Without being out, he has.
You have filed the appeal with be inside, Mr. Dotto.
Applicant is
Ah.
inside the.
AI, you are AI. We know. That is why we're telling you. This is that old computer, so it takes some time. Bhattakur is middle computer. You are AI. Man is inside the jail, you are filing it. So see, so fast. So get this instruction also. We'll finish it up.
I'll take it.
And your statements here is, there is nothing left to be
Yes,
considered on merits.
Of the record, I am saying there is nothing, no merit in this
And
mind.
then that's it.
Keep your place.
I have done it for the benefit of Mr. Bhattakur.
Yes, yes. Trying to direct lordship in.
Yes, madam.
A is for delay.
But Ms. G. Deka, Lana Counsel for the petitioner. The present interlocutory application has been instituted, praying for condonation of a delay of 68 days in preferring the connected revision petition. Also, issue notice. Mr. B. Sharma, London. Additional public prosecutor accepts notice on behalf of respondent number 1. For petitioner to take steps for service of notice upon respondent number 2 by way of register, by way of speed post. By way of speed post or by way of the, what do you call that? No, register post, no, it's not there. Key notification also. By way of speed post. Steps within 2 working days. Register to list this matter again after 3 weeks on a date to be fixed by it. Now, this is issue between the husband and the wife. Why have you brought in Mr. Sharma unnecessarily? He'll be the Kaji, Mia Bibi.
Honorable Court, Lord.
Court,
That
it's
is
a 125, it's a proceeding between you two. Why should Basara, he is brought in. What will he do? 24.
There's a 82 application, my lord. Fire is at page number 45, my lord.
You have got the case diary? No, you have got the case diary.
There is a LCR has been called for and the CA has been received, my lord.
Scan copy is any. Sheet file.
Actually, has not been filed till date, my lord.
Then what scan copy has come? Some scan copy.
Stated in the cause list, my lord.
Just give me a moment.
That no charge sheet has been. The case where these are the petitioners, all the petitioners are from the. They have come for the refugee status because persecution, war, and everything happening in the Myanmar.
Oh.
They have the cards, my lord, UNHCR cards. They have been issued cards, before expiry of the UNHCR card, they were arrested while they were traveling from Jammu to Assam for in search of livelihood. There is no threat, my lord.
Rohingyas.
Yes, Rohingyas, my lord. No threat, nothing, my lord. We're just traveling from Jammu to Assam in search.
Yes, Mr. Sharma. This
They
is
are
a
in
serious
jail.
matter. Why the case diaries are not on record?
Till date, my lord, it has been pending since.
10 records are there, Lord.
Scan TCR would be nothing.
Nothing has been done, my lord. They are still in custody. They have small kids, my lord.
This is only with regard to the applications made.
No investigation, nothing has been done. They are suffering in the jail, my lord.
Where they have been kept at Matia or
Silsar itself
Silsar.
Fix the data.
has been going on that man.
We understand, but we also should be very sure with what exactly is the allegations leveling is this person. It's a pathetic thing, but can't help it.
No, there's central government.
They have been given refugee status. They have that certificate. So what would be the
My lord, may kindly see the FI. There is nothing.
no, criminality is not required, but they are foreign nationals. Where is the FIR?
Why is it page number 45, my lord? The brief of the case is that on
They don't have the typed out copy. Ah,
brief of the case is that on 29/5/2020, complaint is to the effect that 30 am, the complainant ASI Samiruddin Lashkar along with the staff of has intercepted vehicle bearing registration so and so Janikan Silsar, who were suspected to be the foreign nationals. Accordingly, the passengers, as noted below, were asked to give the relevant details regarding their identity.
there were some proceedings in the Supreme Court. What happened on this? The issue of Rohingya, this arrest and all those things.
They were asked to issue the UNHCR cards, but that's not allowed.
Where Malat, not in this case, Malat, but where conviction is there, after that conviction also, Malat, maybe 6 months, 3 months conviction. After that conviction period also over, they has to be stay in the detention camp. Because either they have to be go to their origin
Myanmar.
country, or those people are seeking this type of Malat, from the United Nations Human Rights Commission Malat refugee status. So India in those I file affidavit that India is not a signatory of United Nations Human Rights Commission because of
I
that.
have proof for that.
Course,
Judgment
Malat.
to the state effect, madam, and if the India is not a signatory, but they respect it, my lord.
Respect it and
Malat,
binding is two different.
Binding is, my lord, because refugee status, because there is judgment to the state effect of honorable.
And one case Malat, now still pending. They want to go. They want to go
To Myanmar.
to Bangladesh. But in that case, either to push back is another thing.
No. Bangladesh, that is a different aspect altogether. They will come within the purview of the
without
tribunals.
any document, valid document they have.
No. If it is from Bangladesh, then it will be before the tribunal.
Yes,
Ah,
no,
but this will not go before the tribunal.
The tribunal, they are not saying that they are not Bangladeshi. They are saying that we are Bangladeshi.
Bangladesh.
We want to go. That in that case also, Malat, procedure has to be now.
Paragraph number 6. It starts from 6, my lord. At the outset, the admitted position is
Just
that
a moment.
7, 8, 13 and 19, my lord.
I think they were not given that,
They were not given.
that
No,
this is after, this stage is after this.
Yes, they were asked to give. Then they were asked this.
To approach and consider. But here the UNHRC status is there.
Yes, my lord.
That's
Mr.
a different thing. Now the court.
No, you get the case diary?
It has been pending for the case that since.
Urgently,
Mr. Your GR Dotto,
A.R. Borua.
AR Borua, learned counsel for the petitioner, also heard Mr. KK Parasar, learned additional public prosecutor appearing for the state. Mr. Parasar submits that the matter be taken up on, give me a date on that day, invariably produce, or we'll have the IO. When? 11/11/2025, on which date he submits that he shall invariably produce the case diary. Also, registry to list this matter again on 11/11/2025 for production of the case diary. If not produced, we'll pass
Yes,
the
ma'am.
requisite orders. Hansi,